What is the substitution? ELA. ELA. That is the correct ELA.
No problem.
This is an order of 19th of March. You have filed your affidavit. Filed your affidavit. Yes.
Yes.
You are agreed by the fact that she was allowed to, the caveatrix was allowed to file her affidavit in support of the caveat out of time.
No, my lord. There are 2 points, my lord. This is one of the reasons, my lord. Kindly, I'll take your lordship note of the fact that normal.
Yes.
Yes.
marked as a contentious clause.
My lord, may I just submit, my lord? In normal course of event, my lord, everybody who has a caveatable interest, my lord, is entitled to contest the proceedings, my lord. But, my lord, one has to come before this honorable court, my lord, with clean hands, my lord. A person, my lord, who does not come before this honorable court, my lord, with clean hands, my lord, does not, my lord, does not deserve any leniency, my lord, on the matter of fact, my lord. My learned friend, my lord, the probate proceedings were filed before this honorable court. In the year 2023, my lord, the mother, she's a 90 plus lady, my lord, through her constituted attorney, filed a suit before the London Alipur court, my lord, for partition. In the said suit, your lordship will find she has spelled out her name as Illa Addi only, ILA Addi. There's an application by my learned friend where my learned friend has annexed a document, my lord. In fact, the record will show that she has been spelled out as Illa Addi. Thereafter, my lord, special citation was issued. Special citation was issued, my lord, at the correct address where
She is your mother-in-law,
she is my mother-in-law.
and you don't know the correct spelling of her name.
No, my lord, kindly take page 80. She writes both. It is not, kindly take page 80. I will
Very well. She writes.
that.
She writes
It is
both.
Illa or Illa.
She writes
It
both.
makes no difference, my lord, whether she has been spelled out. That is not the ground for my filing an appeal or seeking discharge of the caveat. What has happened, my lord, that in the said suit, I had disclosed the fact of filing of the
You are the sole beneficiary under the will.
yes, me and my daughter.
Testator has not left anything to the mother.
No, mother was given a life interest because the property originally, which is apart from the other assets, my lord, was that testatrix had a life interest in the property. Then there was a partition deed, family settlement between the two sons of the lady. In the said suit, my lord, she filed a settlement. She challenged by filing a title suit before the London Alipur court. Property was given to for the development. Matter came up before this honorable court. This honorable court, my lord, when the matter came up here, my lord, the matter was mutually settled between the parties. That was in the lifetime of the deceased, my lord. The 2012, it was settled, and it was agreed that the property which will be developed, my lord, where she will get a flat. And one flat, my lord, in the meantime, she would get at Fort Oasis, 37 by 1 Panditya Road for her residence. And my lord will also provided that Sudhir Reddy that both the children will pay rupees 15,000 per month. This was the original will of the deceased father Sudhir Kumar Reddy. From that, my lord, in 2015, for initial period, Mrs. Illa Reddy stayed at Fort Oasis. Thereafter, she shifted to 97 by 1B Hazra Road.
Yes.
97 by 1B Hazra Road. In the suit which has been filed in the year 2023, my lord, we disclose the fact of filing of the probate proceedings before this honorable court. In the long back 2023. Special citation was issued at 97 by 1B Hazra Road, where she was residing with her elder son. Now, my lord, there is no dispute with regard to the fact that she is residing at 97 by 1B Hazra Road. It is her categorical admission in the title suit number filed in the year 2015. Thereafter, in the present proceedings also, in GA number 3 of 2024, which she had taken out, my lord, she had admitted that she is residing at 97 by 1B Hazra Road. Now, my lord, kindly see the application which my learned friend, what had happened thereafter, my lord. After the citation was issued, my lord, we obtained a certificate. We mentioned the matter before the honorable court.
Yes.
Matter appeared before my lord Justice Apurva Sinha Rai on 13th of May 2024. There, my lord, my learned friend appeared.
Chapter 35. Yes.
There, my lord, my learned friend appeared. And before the honorable court, they took the point that the name has been incorrectly spelled out and we were directed to serve the copy of the probate petition that was being served. Thereafter, another order was passed on 17th of May 2025, whereby liberty was given to my learned friend to file an application with regard thereto and to file wakalatnama. My lord, and that time was granted till 14th of June 2025. On 14th of, instead of taking out an application in terms of the liberty granted by this honorable court, my lord, kindly take page 47. 47 first.
Are you carrying AI 1959 Calcutta with you?
Nandalal said, Nandalal says that judgment was there. Yes,
Nandalal sir.
it is 54 Calcutta.
Nandalal sir. 1954 Calcutta.
No, 59 Calcutta I don't have, my lord. Nandalal said 55 Calcutta. It is 55 Calcutta, no. Nandalal said judgment. My lord, I have got that Nandalal said judgment. একটা copy আছে।
আমার কাছে একটা কপি আছে।
59 Calcutta we don't have, not Nandalal. 59 Calcutta का नाम कौन है? Simply के होता है। दिवाकर को है। दिवाकर
नहीं,
तो देखिए। दिवाकर को फोन करके
That
लाइट
is 54 and the one which the court has relied upon 59 is.
On both.
59 কপি আছে আপনাদের? কোনটা কি নাম আছে গো? গণপতি সরকার এটা গণপতি সরকার that Manupatra version. But I have got a one
Same.
copy of that.
Yes, Ms. Agarwal.
Yes.
We are listening.
My lord, by an order of 17th May 2024, my lord, my learned friend was given a liberty by this honorable court that you take out an appropriate application with the name ELA Addi. That order was passed on 17th of May 2024, which is at page 47. Then, my lord, kindly come to page 48. The liberty was granted to file the application by 14th of June 2024. But on 14th of June, my lord, in 2024, my lord, instead of taking out any application in terms of the liberty granted by this honorable court, my lord, a caveat was sought to be lodged. Kindly see the caveat which is at page 48. We have obtained a certificate from the registrar. At the request
Anything under the. Yes.
Yes, my lord, kindly come to page 48, my lord. Just, I'll not take much time, my lord. At the, I do.
Chapter 38, Rule 46.
Yes, I've got. My lord, I'll come to the original side rules, my lord. I'm not, I'm aware of it, my lord. Kindly come to two things which I would show. My lord, what is the stand that has been taken by the caveatrix, my lord? I do hereby certify that Ila Addi, represented by the constituted attorney Viswajit Addi, has filed caveat on 14th of June 2024 with an undertaking. No citation has been received by the caveatrix till 14th of June 2024 through her advocate. But she has not filed her affidavit in support of the caveat till date at 11 a.m. This was being, as it appears from the legend maintained by the testamentary department. My lord, this was an caveat was lodged on 14th of June 2024. Now, in terms of the original side rules, my lord, no notice of lodging of the caveat was being served on 14th of June. No application was being taken out. Then, my lord, in the month of September 2024, after this certificate was being obtained on 30th of September 2024, we took out an application that caveat filed by Viswajit Addi on behalf of Illa Addi be discharged and Vakalatnama be cancelled. After that application was being served upon my learned friend, my lord. After the matter was being taken up by the learned single judge, my lord, they took out GA number 3 of 2025, my lord, on stating that on the two ground, which is at page 69. My lord, the master summons is at page 65.
Yes.
My lord, the time to file the present affidavit in support of caveat be enlarged and the affidavit in support of the caveat be taken on record. B. Mark the instant probate proceedings being paid in 2023 as contentious cause. Direct the applicant to take necessary steps for correcting the name of the applicant in probate petition as well as in the record of the case. This application was taken out on 12th of February 2025 when my application for discharge of the caveat was being heard. Now, the grounds which have been taken in the said application, my lord, are glaring, my lord. Kindly see first page 69. Kindly see, my lord, the cause title, the address of Mrs. Illardi, my lord. Presently staying at premises number 97 by 1B, Hazra Road, Kolkata 26, the caveatrix herein. It is not Fort Oasis, 37 Panditya Road, which has been recorded in my lord's order, the learned single judge, and the case made out in the present petition. Then, my lord, the ground on which my learned friend seeks liberty, kindly see, my lord. These paragraphs, my lord, paragraph 3. The caveatrix has come to learn about the instant proceedings being instituted at the behest of the executor Srimati Ipsita Addi when a notice was attempted to be served upon her eldest son's residence lying situate at 97 by 1B Hazra Road, Kolkata 26. During such service, the eldest son of the caveatrix, Sri Samir Kumar Addi, who had recently lost his eldest son-in-law to cancer after fight a long battle in Emory Hospital, Dhakuria, and as a consequence whereof an attempt to serve notice failed due to non-availability of Sri Samir Kumar Addi or his family members at their address. Then an information was left behind by the postman who had come to deliver such notice with one of the office staff of Sri Samir Kumar Addi to have such notice collected from the post office. The power of attorney holder of the non-agrarian caveatrix, being the grandson of the caveatrix, visited the post office in order to get the notice collected. When he was informed that the notice bears the name of Mrs. Illa Addi, and as such the same cannot be handed over to anyone else apart from the addressee unless the concerned person can produce an authority to collect the same. However, the said constituted attorney of the caveatrix, upon coming to learn about such fact, produced the power of attorney in order to have such notice collected on behalf of the
Mr.
caveatrix.
Agarwal, the learned single judge has recorded what the grounds are.
My lord,
Please don't read out.
my lord, I'm not recording. Why, my lord? Here, my lord, the ground is being taken. Kindly see, I'll not take the page 4, my lord, paragraph 7. Kindly see. In this context, it is pertinent to mention herein that the address of the caveatrix is Fort Oasis, 37 Panditya Road, Kolkata 29. And the notice which are sought to be served upon the caveatrix is not a residential address. which is address of our elder son, 97 by 1B Hazra Road. Second, and my lord, kindly take the affidavit, my lord, that has been filed after the losing of caveat. Kindly take. Her address is being given. The oath commissioner has gone to the residence.
Mr.
And-
Agarwal, please understand something. The caveatrix is 96 years old. She is operating through a constituted attorney. Even assuming there's some irregularity committed by the constituted attorney, we are not going to penalize the caveatrix for that. Your stand is mala fide, we think. She is your mother-in-law, and we will not allow her to contest.
My lord, I will not say anything, my lord. But my lord, this is what precisely I'm saying, that mother-in-law is not contesting.
That you
Mother-in-law is
find
not.
out by cross-examining
My lord,
at the trial.
my lord, let me, because now since they have filed an affidavit, my lord, because the order has records, my lord, the fact GA3 says that they were not aware that after caveat closing of caveat affidavit was to be filed. I accept all this, my lord. The affidavit has come now. But what I require submit, my lord, that since the caveat is 96 years old, my lord, I have taken instruction from my client, my lord. My lord, because let her evidence be recorded first, my lord.
Go and
Considering
make that prayer before the learned judge.
my lord,
Who stops
and
you?
my lord, a time limit be given, because and the partition suit which is filed in the Alipur court be transferred here, my lord. Let the suit, both the same
Make
can be
all
tried.
those prayers before the learned single judge. Isho.
May I just submit, my lord? May I just submit, my lord? Kindly see the finding that the court has recorded. My learned friend has said that she is residing at Fort Oasis. They could have simply approached the learned court, my lord, with the prayer that we want to contest, and application ought to have been taken out, but instead they waited for so long. And my lord, the constituted attorney and the eldest son, my lord, who is fighting the entire proceeding on behalf of the lady. Lady is not contesting the proceeding. So, my lord, lordship can pass an order, a consent that later evidence be recorded. I will not press the appeal, my lord. Later
Are you bargaining with the court?
No, my lord, I'm not bargaining. I'm
You
just
are.
submitting. No, my lord, I'm submitting.
We are not going to pass it in such direction. Go and make such prayer before the learned judge.
Very well, my lord. Then in that event, my lord, I will not press the appeal with liberty to apply for recording of our evidence, my lord.
Half an hour on this, Ms. Agarwal.
My lord, because
Is this fair to the court,
I'm sorry.
to your fellow advocates,
My lord,
to the litigants?
My lord, their application contained utterly false statements, my lord, on oath. But since the mother-in-law, my lord, I don't want to contest.
After arguing for half an hour, learned senior counsel representing the appellant says that she doesn't want to press this appeal. Paragraph, the appeals and the connected application stand dismissed.
And my lord, kindly give me the liberty to apply before the court for examination.
Nothing. Nobody needs to give you liberty. Go and apply.
कोर्ट चाहिए माँ के कंटेस्ट को जब मैं कौन टाइम देकर तो जाने दूंगा तो कोई चीज तो आप मैं
Okay. Mr. Pradeep Ghosh is.
Yes, yes. There is a. But I have, Millard, troubled your lordships for 3 days. Today would be my penultimate day to before closing my opening arguments, Millard.
Penultimate day. You will not conclude today.
Yes, I will. And then Mr. Ghosh will take up,
Yes,
Millard.
of course.
And I will have probably a right of rebuttal
Yes, yes.
much later
Of course.
when Mr. Ghosh finally concludes, Millard. But I had, Millard, broadly, Millard, covered the majority of my submissions on the earlier occasions, Millard. I will take your lordship to the impugned order.
Mr. Ghoshal, just
Yes.
to recap,
Yes.
the short issue, as I had noted,
Yes.
is whether the appellant was entitled in law or under the contract to collect stowage for
Storage,
excess
yes.
cargo
Yes.
brought in without notice under clause 5.12 of the
Precisely.
short-term agreement.
Precisely, my lord. That is the only point, my lord. That is the only point, my lord. I will place, my lord, a little bit of the impugned order, my lord, and where the learned trial court, my lord, trial judge, my lord, the section 34 court, my lord, while dismissing the majority award, my lord, have, my lord, probably, my lord, have gone beyond, my lord, what otherwise would have mandated, my lord. And then, my lord, a few decisions, my lord, one of a very recent one on a BBM Industries, my lord, I would like to cite along with and my lord, Gayatri lordship.
That's a wrong decision.
I would rather cite a wrong decision, my lord, to make things right, my lord.
Yes.
My lord, lordship will kindly take, my lord, page 13 of, my lord, the memo of appeal, my lord, internal page 13 of the impugned order, my lord. I'm not reading out the italics portion, my lord. I had placed it on the last occasion, my lord. The minority award, my lord, in a way, my lord, said that at best, if we would have got an amount, that would have totaled to an amount of 2 crore 53 lakhs and not what the majority award has held, award gave us, my lord, gave the appellants, my lord. But ultimately, my lord, we were not entitled to anything. What that was the minority award, my lord. May I, my lord, thereafter place from
Minority award has been upheld by
yes,
Learned
yes,
single judge.
yes, yes, yes. Now, my lord, may I please, my lord, from page 13, my lord, not the italics portion, my lord, immediately after that, my lord, on consideration. She has got that paragraph, my lord. On consideration of both awards, it reveals that the majority arbitrators, while considering clause 5.12, come to the conclusion that the first part of the said clause is applicable, and in terms of the Major Port Act 1963, the tariff authority of major ports, the respondent is entitled to claim demurrage. The minority arbitrator, while considering 5.12, considered the charts showing cargo handling during the said period and held that the second part of clause 5.12 is applicable and the respondent is not entitled to claim demurrage. There is no provision in clause 5.12 of the short-term contract that demurrage is payable in accordance with TAM scale of rates. In clause 3.3 of the short-term contract, the respondent confirms that 40,500 square meters of area will be utilized for handling the cargo, and mechanized handling facilities, drains, roads, railway tracks, buildings, amenities, and other systems associated with providing integrated terminal services as per this agreement. It is crystal clear that the said area is also provided to the petitioner for stacking cargo and dispatch of cargo. But perhaps, my lord, while expressing its mind, my lord, his mind, the learned 34 court, my lord, probably have, my lord, transgressed, my lord, the concept of stacking cargo and keeping the cargo as a transit area, in the transit area. So there's a difference, my lord, between keeping the cargo in a transit area and stacking the cargo for a longer period of time. It was never a agreed possession of between the parties, my lord, that the cargo has to be kept for a longer period of time, as in stacking the cargo, blocking an area of the port. It is always the cargo will come in, it will be unloaded. That's the transit area. The cargo will be weighed after all the clearances and statutory obligations are met. The cargo will go out, my lord. So that is the only for the limited purpose, and that is precisely clause 5.12 gives a period of 15 days free period is granted, and a maximum cap of cargo was given, my lord. What you would recollect, my lord, 60,000 plus 30,000, and then another 30,000 for the second part, which is if it goes beyond 2 million metric tons per annum, my lord. That's the second part, which I'm not concerned with that, my lord. Now, my lord, may I read out, my lord? In clause 4.1 of the agreement, the integrated terminal service has been specified. In the said clause, it is also mentioned that the subsequent year, on the year escalation in the ITSC from the end of the first year of operation is detailed in annexure 1. And in the said annexure, there is no mention of payment of demurrage as per the TAM scale of rates. Now, interestingly, the annexure that the learned judge has referred to is the same annexure which I, while making my opening argument, showed your lordship, which is a part of the STA, which mentions TAM scale of rates will apply. Now, my lord, clause 8 provides for review, and the review meeting was held on 9th October 2009. In the review meeting, also the respondent did not discuss about levy of demurrage and revision of terms and conditions of the terms of the contract for inclusion of claim of demurrage. In the order passed by TAMP dated 11th October 2011, it is held income, there's a chart mallet given. 4 is income estimation. Roman 1 on the left hand column, the VSPL has mentioned about a bilateral agreement with SAIL under which discounts in tariff were allowed by VSPL and requested not to ignore the revenue discount offered by it to the SAIL in the tariff revision exercise. In this connection, it may be noted that the authority in some other general revision cases has decided that revenue realizable at the rates approved is to be considered, and reduction in revenue due to concessions granted by the port private operator at its discretion will not be considered in the tariff revision exercise. The revenue impact of such discounts allowed by VSPL may be quantified for each past year, and the cost statement may be modified to show revenues realizable at the approved scale of rates. Now, the other side of the column, millet, speaks of millet. A, SAIL is the only major customer importing coking coal through gearless Panamax vessel in Vizag. I'm sorry. As TAM, I'm sorry, millet. SAIL is the only major customer importing coking coal through gearless Panamax vessel in Vizag port for about 5 MNMTs and 5 million metric tons, I believe, Millard. As TAMP is aware, RNIL, that's Reliance, that's not RNIL. Not okay. Okay. Okay, I'm sorry, Millard. I'm unaware about this. Limited, Millard. Coking coal hit her to handled at Vizag port has fully migrated to Gangavaram port, hence the operational viability of VSPL and protection of cargo volume in VPT. It is absolutely essential for VSPL to retain SAIL cargo. Keeping this in view, a 4-year short-term agreement with SAIL was entered with effect from 6/5/2008. As such, giving reduction in approved tariff to SAIL is purely out of the contractual necessity and compulsion to retail SAIL cargo at VPT VSPL. Now here lordship will find Millard VPT stroke VSPL. So when I was arguing on the previous day, Millard, I say that I become, once it's a BOT type contract and I step in, I become the port. So I am having I may not have an ipso facto control over the land of the port, So I cannot give it out on lease, but I can exercise all the powers and functions that is vested to the port by way of a statute and can apply them in the cases where I am operating from one or more than one berth. Till such time, I am in absolute physical control of the berths and I am entitled to do everything with connection there to Millet. So, Millet, here the expression is also VPT, VSPL. So, they are also, Millet, TAMP is also identifying VSPL being port and in making such identification, Millet, the TAMP is basically kind of, Millet, making VSPL also aware of the fact that they are in turn entitled to storage charges if there is an excess cargo, Millet. Thus, there is absolutely no discretion. May I read up? May I read there from Millet? Thus, there is absolutely no discretion from our end in granting reduction in tariff to sale. It is again submitted that concession in tariff to sale is also in accordance with the TAMP guidelines 2.16.1, 4.4, and as advised by TAMP vide reference number Roman 17B of the earlier tariff order. Now, the fine line of distinction, if I may pause here for a moment and say, Millard, is whether tariff would include storage charges. My submission is tariff is exclusive of storage charges. Tariff is a fixed rate, that is the integrated terminal service charges, that is 167 rupees per metric ton, which I am entitled to get. I am getting that only to the extent that if I am not storing, if sale is not getting excess cargo and making me store that excess cargo beyond the period of 15-day free period, Millard. The moment that happens, Millard, the question of tariff stops and the question of storage comes in, Millard. So I had an option and I had exercised that option, Millard. That is, Millard, precisely my case is, Millard. May I read thereafter, Millard? In the said order, the TAMP has categorically recorded as such giving reduction in approved tariff to sale is purely out of contractual necessity and compulsion to retail sale cargo at VPT VSPL. Thus, there is absolutely no discretion from our end in granting reduction in tariff to sale, and we are not in dispute at all with this regard, Millard. We are not in dispute. We are ad idem on this point that yes, this reduction was given, Millard, but not with regard to my entitlement to receive storage charges in case of excess cargo, Millard. Nowhere it has been spelled out, Millard. Millard, thereafter, Millard, a case law has been cited, Millard. I'm skipping that paragraph, Millard. Another case law, Millard, has been, Millard, discussed, Millard. I'm skipping that as well, Millard. I will come straight away, Millard, to the findings of the learned 34 court, Millard. Page tab also. Millard, take page 20 onwards, Millard. 21, I mean 20 to 40 paragraph now. I'm skipping the italics portion, Millard. In the present case, the majority arbitrators have taken into account of the Major Port Trust Act 1963 and TAMP order, which is not available in the contract, and have not considered the chart showing the cargo handling during the contract period, which was the material documents available with the arbitrators. The minority arbitrator has considered the said document and also held that in the present case, the party are to be governed by private contract and not the Major Port Trust Act 1963. The learned minority arbitrator also considered the letter issued by the respondent, wherein the respondent insisted the petitioner not to divert its vessels even on the day the ground stock was 85,099 metric tons. the respondent had protested the diversion of cargo not because the petitioner did not fulfill the commitment quantity, but to ensure it does not lose revenue. In the letter dated 20th of January 2011, it is also mentioned that diverting the vessels to Gangavaram would cause huge loss of revenue. In the case reported, Malad, then another case was been Malad 21, I'm sorry, at a 2012 hobe na, this is a citation is, Mr. Ghosh says that it's AIR 2021. PSA Sickle Terminals, Malad. I will, Millard, skip, Millard, this part, Millard, and come straight away to page 21, Millard. The case law has been, Millard, briefly, Millard. Paragraph 87 has been, Millard, relied upon, Millard. Thereafter, Millard, in the instant case, the majority arbitrators have passed award by going outside the four corners of the agreement, in spite of the fact that there is no clause in the agreement for levy of demurrage against the petitioner, and have considered the major port trust, which was not the subject matter before the learned arbitrator under the contract. Willard, pausing here for a moment, Willard, I believe, Willard, the annexure A, annexure 1, which forms the part of the agreement, does mention about the applicability of TAMP. And when it does mention applicability of TAMP, and when, Willard, the provisions of the scale of rates becomes applicable in case of excess cargo, Willard, in my respectful submission, Willard, the majority award is, in my opinion, it is right, correct, Millard, and there is no scope, Millard, for the Millard 34 court to Millard travel, Millard, beyond the scope of what the majority award has been, Millard, spelled out, Millard. Here, Millard, sales responsibility. Thereafter, Millard, clause 4 has been, Millard, enumerated, Millard. Now, again, in page 22, Millard, the learned 34 court, Millard, did, Millard, refer to an annexure 1, where question of royalty comes in, VPT TAMP notification is mentioned, Millard. Then I'm not on the first power part, Millard, that's Andhra Pradesh Electricity Regulatory Commission, Millard. I'm not on that, Millard. Again, Millard, VPT notifications, Millard, have been mentioned, Millard. That's the quote. Basically, annexure 1 has been quoted, Millard. Millard, I will skip then, Millard, page 23, Millard. Then at page 20, I'm sorry, Millard, page 23, keeping in view, may I read from there, Millard? Prashwell got that page, Millard? Keeping in view, Millard, prior to that paragraph, Millard, the demurrage thing has been, Millard, spelled out, Millard, how demurrage stroke storage charges, Millard, that has been, Millard, spelled out, Millard. Again, Millard, the learned 34 court, Millard, have, Millard, failed to, Millard, distinguish between the demurrage charges stroke storage charges, Millard. Those are two different components, and we insist on saying that we are entitled to storage charges of excess cargo, Millard. Millard, keeping in view the principles of law laid down in the judgments referred to above, I shall now proceed with the matter. It should be further noted that in the instant case, award came to be passed prior to October 2015, and as such, section 34 of 96 would say of 1996 would apply. A reading of the above judgments make it clear that the scope of interference would be only when the award is against public policy of India or came to be passed contrary to the terms of contract, or whether award is so perverse which goes to the root of the matter, or whether arbitrator construe the contract agreement in such a way that where no fair-minded or a reasonable person would do. Admittedly, there is no clause in the agreement or there is any correspondences between the parties with regard to imposition of demurrage upon the petitioner. Under clause 4 of the responsibilities of the petitioner, sale is provided. Penalty made under clause 4.2 and is in the said clause also there is no provision for demurrage. There is nothing in short-term agreement with regard to applicability of Major Port Trust Act or TAMP order. In the year 2011 itself, TAMP has decided on the reduction of tariff. Then the next paragraph, further, the payment of loss or the demurrage may be to be reimbursed, in my view, may not be a ground to reverse or rewrite the tender condition as it was not accepted by the petitioner. Dealing with rewriting the terms of the agreement, the Honorable Apex Court in Satyanarayana Construction held that as per the contract, the contractor was to be paid for cutting the earth and sectioning to profile, etc., at the rate of 110 rupees per cubic meters. There must be some merit in the contention of Mr. Such and Such that the contractor was required to spend huge amount on the rock blasting work. But in our view, once the rate has been fixed in the contract for a particular work, the contract was not entitled to claim additional amount merely because he had spent more for carrying out such work. I'm sorry. I will not trouble your lordship. This is what the learned arbitrator, learned 34 court held, that since it has been spelled out that 167 is the ITSC, I am only entitled to get 167 and nothing more, That is what in while dealing with Satyanarayana Construction, that is what the learned 34 court, I will skip a few pages, I will take your lordship straight away to page 30. The patent illegality. I will skip the italics paragraphs, Millard. Which will take from the paragraph the patent illegality. This is the operative portion. Now, Millard, interestingly, Millard, all this has been discussed, Millard, and why this award, the majority award, would fall within section 34 and the 4 parameters where the court can intervene, Millard, and can reverse the set aside, Millard, the award. That has not been clearly, Millard, demonstrated in my understanding what I have found out, Millard, from a plain reading of the order, Millard. The patent illegality is permissible ground for reviewing a domestic award, vide ruling in Delhi Airport Metro Express Private Limited with the Delhi Metro Railway Corporation. What would constitute patent illegality has been elaborately discussed in Associated Builders, wherein it has been held that patent illegality falls under the head of public policy. Failure on the part of the majority tribunal to decide in accordance with the contract governing the parties would be opposed to public policy, and awarding the claim contrary to the terms of the contract goes to the root of the matter. Ignoring the terms of the contract amounts to gross contravention of section 28(3) of the Arbitration and Conciliation Act 1996 that enjoins the arbitral tribunal to take into account the terms of the contract while making the award. To sum up, in the instant case, the majority members of the tribunal have passed an award by directing the petitioner to pay an amount of 19 crores 68 lakhs 46,018 along with interest at the rate of 8% from the date of reference till the award and 6% from the date of award till realization, ignoring the terms of contract in making the award warrants invocation of the award vested under 34 of the Arbitration and Conciliation Act in view of the award, above award passed by the majority, is set aside, Millard. So this is a 1.5 paragraph finding of the learned judge, Millard, while setting aside the award. Now, Millard, may I again, my lord, is for also for my convenience. If I may place section 34 once, my lord. Soft copy नहीं है ना? Hard copy नहीं है?
But the petition by Vinda is supposed to be read into the contract. You will continue for how long, Mr. Ghoshal?
My lord, I will show this 34, my lord, and then I will go to the judgments, my lord.
No, we are asking for another half an hour.
Half an hour. Yes, yes.
12:30, we have an appellate side matter fixed. So just for your information. That's 3:30.
3:30, my lord. I won't be there today at 3:30. I have a doctor's appointment today at 3 o'clock, my lord. So I.
No, but we'll hear the other parties.
Yes, yes. Because I have. I wish, sir. Milad. Before I take your lordship to section 34 of the Act, Milad, uh, the purpose of having annexure 1 as a part of the short-term agreement, Milad, the statutory requirements, because I am not operating at a land which is independent. I am operating in a land which is a land controlled by some other entity, which is a statutory entity. I am fastened with all the liabilities of that statutory entity whose functions I am entrusted with to carry on, Millard. So, by the dint of Annexure 1, Millard, the statutory compliances are to be read along with the contract and not in derogation thereto, Millard. Say, for example, Millard, drawing a larger perspective, Millard, in a similar kind of a contract, if while, Millard, the vessel comes in, Millard, and the vessel capsizes, Millard, just before the berth, the vessel capsizes, Millard. Now, a private party is controlling that. Port has no control, express control, but under a BOT contract, say VSPL is only controlling that particular berth where just incoming vessel capsizes, Millard. Salvers come in, Millard, takes out the vessel, or a vessel gets abandoned. Now, port, for blocking a berth, is entitled to, Millard, a fee. That is also fixed under the TAMP. So who is supposed to collect it? Port is not there in a BOT type of contract. VSPL comes in, a vessel is blocking the berth, other vessels cannot come in. Say, for example, if it is not an exclusive berth or a general berth, but VSPL has control with regard to that, Millard. If a vessel is blocking a berth and port is otherwise entitled to get some amount for excess stay of a vessel in the berth, port is entitled to claim that under the tariff authority of major port, Millard. That is also fixed under the scale of rates, how is to be calculated and how I am entitled to, Millard, collect it. Now, port is not there. I put this question to myself, then who is supposed to collect it? If I am in control, I am supposed to collect it. Similarly, Millard, in a transit area, if it is specified that this is the free period, and within that free period, you are entitled to keep it till the maximum cap and not beyond that. If you want to keep it beyond that, you give a 30 days clear notice that I'm bringing in excess cargo, enabling us to create a mechanism to take it out within a free period, not beyond 15 days, but within 15 days, that too on an excess cargo, on a maximum cap, that too with a 30 days notice. All these are connected, Millard. If any of the parameters fail, Millard, I am blocking, or rather, the person who is bringing in the cargo, in this case, Millard, sale, is blocking port land. And port cannot claim, because port is not in operation. I am in operation under a BOT type of contract, so I claim. So that is the distinction, Millard, that perhaps the 34 court failed to, Millard, draw. And the statutory requirements are embedded by the dint of this Annexure 1, which is made an integral part of the short-term agreement, Millard. Now, Millard, may I take your lordship to section 34? We have read it, Millard, many times, my lord, but every time I read, my lord, I think, my lord, I tell myself, my lord, there's something more I can, my lord, really carve out of it, my lord. 34.1, recourse to a court against an arbitral award may be made only by an application for setting aside. I'm not on that, my lord. 2, an arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record of the arbitral tribunal that the party was under some incapacity, or 2, the arbitration agreement is not valid under the law to which the parties have subjected it to, or failing any indication thereon under the law for the time being in force, or 3, the party making the application was not given proper notice of appointment. 4, the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decisions on matter beyond the scope of submission to the arbitration, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted, only that part of the arbitral award which contains decisions on matters not submitted to arbitration may be set aside. Or 4, the composition of the arbitral tribunal or arbitral procedure was not in accordance with the agreements of the parties unless such agreement was in conflict with the provision of this part, from which the parties cannot derogate, or failing such agreement was not in accordance with this part. B, the court finds, ideally, I may come under 4. If so, other clauses I will not come in the present context, my lord. B is, if the court finds that the subject matter of dispute is not capable of settlement by arbitration, I do not fall under this category, my lord. 2, the arbitral award is in conflict with public policy of India. I may, my lord judge, may have felt that I have come in this clause, under this clause, which has been spelled out in one line, but no elaborate discussion has been made as to why the award is against public policy. But merely stating that the award is against public policy would not do, my lord. My understanding is, if I am earlier, my lord, in 40 awards, Lordship would recollect, most of the awards used to be non-speaking ones, my lord. 33, we used to, my lord, very early days of our profession, my lord, we used to file, my lord. By that time, my lord, when I joined, my lord, 96 came in vogue, my lord, but there were old matters, my lord, 33 applications used to be filed, my lord. There, my lord, there was a scope, my lord, of the arbitrator to pass an award which is non-speaking. Here, the scheme of the act, and after the unification of the arbitration rules internationally, that scope has gone. So merely I just can't, my lord, just scribble a line saying that this is against public policy. Why is it against public policy? Why? It has to be spelled out clearly and in no unambiguous terms. I say, if I write a line saying the disputes are not contemplated within the arbitral agreement, I have to specifically say why and what are the disputes that are not spelled in. Merely by expressing my mind, by writing a line, would not exonerate me, will not entitle me, to set aside the award, my lord. Well, explanation 1, my lord, I'm not going into that, my lord. Fraud, corruption, I will not fall into this, my lord. 2, Roman 2, it is in contravention with the fundamental policy of Indian law. I'm not on that, my lord. Notions of morality of justice, I'm not on that, my lord. Now, my lord, I either will fall under, my lord, 2, 4, or maybe 2B, 2, my lord. Where is the explanation? Pause here for a moment and ask this question. 1.5 paragraph of finding, and that is it. Why TAMP cannot be applied? Where is that explanation? The explanation that has been given by the minority award has been rewritten. Where is the independent observation of the learned 34 court, which would absolutely clean the canvas and say, the majority award is having the lacunas and cannot be given effect to for 1, 2, 3, 4, 5 reasons. Where are those reasons? Your Lordship knows, my lord. I will not trouble your Lordship any further, my lord. I will straight away come to the judgments, my lord. I'll start with, my lord, is a not yet reported, my lord. I'm sure it will be delivered on 24th of July 2025, my lord. BBM Enterprises versus State of West Bengal, my lord. The relevant paragraphs are paragraph 15, 16, 17, 18, 20, 27, 28, and 29, my lord. I'm sorry, my lord. May I come? I'm sorry, my lord. 15, 16, 17, 18, 20, 27, 28, and 29, my lord. I will. May I please? Lordship, the division bench, my lord, had, my lord, in paragraph 14, my lord, also, my lord, enumerated section 34 of the Act, my lord. Paragraph 15, my lord, may I please, my lord. On a perusal of the aforesaid decision, section, it would be clear that the grounds of challenging an arbitral award have been restricted by the legislature. I was just mentioning, my lord, with regard to 1940 Act, my lord, and it has also been spelt out in this judgment, my lord. Under the Arbitration Act 1940, an award could be challenged on various grounds. This resulted in prolongation of the process of resolution of disputes between the parties by resorting to arbitration as an alternative dispute resolution mechanism, since in a large number of cases, the arbitral award was challenged before the competent court. Thereafter, the legal process continued up to the Honorable Apex Court. The intention of the legislature of making an arbitration an expeditious procedure for dispute resolution was often defeated. This was one of the reasons for promulgation of the 1996 Act. The grounds of challenging an arbitral award are now limited, as would appear from the opening words of subsection 2 of section 34, which I was placing before your lordship, my lord. The grounds of challenge mentioned under the section 2 are exhaustive. An arbitral award may be set aside only if one or more of the grounds enumerated in subsection 2 are made out by the petitioner. Subsequently, subsection 2A was introduced, which provided an additional ground for setting aside, my lord. 16. My lord. Next paragraph, my lord. One of the grounds for setting aside an award, if the award is in conflict with public policy of India. Explanation 1 under subsection 2 clarifies when an award can be set to be in conflict with the public policy of India. One such situation is when the award is in contravention of the fundamental policy of Indian law. Explanation 2 under subsection 2 clarifies that in order to ascertain whether there is a contravention of the fundamental policy of Indian law, the court shall not review the merits of the dispute. Under subsection, next paragraph, my lord, under subsection 2A, under section 34 of the 1996 Act, a domestic arbitral award may also be set aside if the award is found to be vitiated by patent illegality appearing on the face of the award. The proviso immediately clarifies that only because the award has resulted from an erroneous application of law, that will not be a ground for setting aside. The proviso further clarifies that the award will not be set aside on the ground of there being patent illegality on the face of the award by reappreciation of evidence. We therefore see that the intention of the legislature was to reduce the role of the court to the minimum, so that the minimal interference with the arbitral process by taking recourse to court. The learned single judge has noted the decision of this court in Lakshmipat Surana versus Voltus, reported in 2019 SCC Online, Calcutta 1008. At para 7 of this judgment, after discussing various decisions of the Honorable Supreme Court and also of various high courts, a division bench of this court held as follows, paragraph 7 within quotes. We do not find it necessary to multiply the references. It is sufficient to recall some of the legal principles which have emerged from a vast body of ever-growing case law of the various high courts and the Honorable Supreme Court of India pertaining to section 34 of the Act may be summarized as follows. A. On a cumulative reading of section 5 of, it should be subsection 5 of, section 5 and section 34 of the Act, it is now well settled that an award passed by an arbitrator can be set aside on limited grounds, and the supervisory role of a court is reduced to a minimum level. It is not permissible for the court to examine the correctness of the finding of the arbitrator as if it were sitting in appeal over an award. As such, a court, while considering the objection under section 34 of the Act, is not expected to reappreciate the entire finding and reassess the whole case of the parties. If the conclusion or the final decision of the arbitrator is based on a possible view of the matter, a court should not interfere with an award. Generally, the conclusion of the arbitrator with regard to the construction of a contract is not to be interfered with if there is a plausible view of the matter, and have even an error relatable to interpretation of a contract by an arbitrator is regarded as an error within its jurisdiction, and as such, it is an error which is not amenable to correction by courts. A perverse finding is one which is based on no evidence, or one that has no reasonable person would have arrived at, unless it is found that some relevant evidence has not been considered, or that certain inadmissible material has been taken into consideration. The finding cannot be said to be perverse. A broad distinction has therefore to be maintained between the decisions which are perverse and those which are not. If a decision is arrived at on no evidence, or evidence which is thoroughly unreliable, and no reasonable person would act upon it, the order would be perverse. But if there is some evidence on record which is acceptable and which could be relied upon, howsoever concise it may be, the conclusions would not be treated as perverse and the findings would not be interfered with. Now, paragraph 20, Lordship has, the division bench has, relied on associated builders, the learned judge also noticed the observation of the Honorable Supreme Court at paragraph 33, of the reported decision in the case of Associated Builders versus Delhi Development Authority, reported in 2015, 3 SCC 449, which reads as follows. Paragraph 33 has been quoted, Millard. It must clearly be understood that when a court is applying the public policy test to an arbitration award, it does not act as a court of appeal, and consequently, errors of fact cannot be corrected. A possible view by the arbitrators on fact has necessarily to pass muster, as the arbitrator is the ultimate master of the quality and quantity of evidence to be relied upon when he delivers his award. Thus, an award based on little evidence or no evidence, which does not measure up in quantity to a trained legal mind, would not be held to be invalid on this score. Very often, an arbitrator is a lay person, not necessarily trained in law. Lord Mansfield, a famous English judge, once advised a high military officer in Jamaica who needed to act as a judge as follows: General, you have a sound mind and a good heart. Take courage, and you will do very well. In your occupation in a court of equity, my advice is to make your decrees as your head and your heart dictate, to hear both sides patiently, to decide with firmness in the best manner you can, but be careful not to assign your reasons, since your determination may be substantially right, although your reasons may be very bad or essentially wrong. It is very important to bear this in mind when awards of lay arbitrators are challenged. Once it is found that the arbitrator's approach is not arbitrary or capricious, then he is the last words on facts. In PR Shah, Share Stocks Millard Report 2012, 1 SCC 549 has been quoted. Millard, I will not trouble your lordship with, I will straight away take your lordship to paragraph 27, Millard. Pausing here, Millard, this Justice Mansfield, Millard, all these, Millard, old judgments are still read, Millard. Interestingly, Millard, Mr. Ghosh has read much more than I have, Millard. These are all old school Eastman color movies, Millard, 70s Hollywood, Millard. Never to get old. Still can watch with the same vigor, Millard. We can still read with the same vigor, Millard. Millard, paragraph 27, Millard. It is too late in the day to dispute the proposition of law that the arbitrator is the ultimate master of the quantity and quality of evidence to be relied upon. The finding of an arbitrator on facts will rarely be interfered with by the courts. Similarly, insofar as the construction of the clauses of the contract is concerned, the arbitrator's opinion will generally be accepted. Of course, if a finding or an interpretation of a contractual clause is perverse on the face of the award, the court may justifiably interfere. In this connection, Millard, OPG power has been, Millard, dealt with, Millard.
28 and 29.
29, Millard. Paragraph, I'm not reading that portion, Millard. 29, Millard. In the present case, the arbitrator has taken a particular view as regards legality or otherwise of termination of the subject agreement. The view does not seem to be Wednesbury, unreasonable, or arbitrary, or preposterous, or perverse. Therefore, I find no justification for the learned trial court to have interfered with the finding of the arbitrator that the termination of the contract by the state government was illegal. Millard, I will not trouble your lordship with any further, Millard, of this judgment, Millard. It has been, most of the judgments, Millard, has been dealt with, Millard, elaborately, Millard. Associated Builders का तो एक और आज
Standing outside.
Oh, standing outside. Then we'll take that up. We'll finish off that. You will anyway. How much more time?
Three more. Associated Builders, Millard, I have already placed it from this one, Millard. I will only give a reference, Millard.
How long? 5 minutes?
5 minutes max.
5 minutes?
I will not trouble your lordship, my lord. I will only give the paragraph
Yes,
numbers,
yes,
my
do
lord. I
that.
will do that.
Do
my lord.
that. Do
This
that.
I wanted to read.
Yes. Yes. Of course.
I should take liberty to read this one, my lord. There's another unreported, my lord, on the same point, my lord. May I? No, tu negulo সব। This is, my lord, Kolkata Metropolitan Development Authority South City projects, my lord. Justice Tandon and Justice Madhuresh Prasad, my lord. This is also a very, also reportable, my lord. My lord. I will only rely upon paragraphs 35, 44, and 45. আমি পড়ছি না, আমি খালি না না 12:30 একটা অ্যাপেলেট সাইড
Paragraphs?
35, 44, and 45, my lord.
Consolidated consortium টা দেখে দাও সুপ্রিম কোর্ট।
My lord, and one more, my lord. And this is, my lord, 2025 SCC Online Supreme Court 956, my lord. Consolidated Consortium, my lord. Software Technology Parks, my lord. This is the relevant paragraphs are, my lord. Oh, yeah. Arbitrator is the master of evidence and point is limiting. On the same proposition I'm arguing, my lord, the one I cited in BBM Industries, my lord. These are paragraphs 22 to 24, paragraph 27 and 28. That is modification. These are the ones, my lord.
Very well.
Well, I conclude my opening argument.
submission.
Yes.
Mr. Ghosh, we'll have
Associated, my lord, Associated Builders has been referred in BBM, so I'm not troubling your lordship with another, my lord. That's the only one paragraph that has been relied upon, paragraph 33, my lord.
এই এটা আমার কবে হবে ইউজুয়াল কোড
Next Wednesday.
Next Wednesday করবেন?
at the same position.
Deeply obliged, my lord. Obliged.
Where is Mr. Das? He won't be arguing. You will argue. No problem. No problem.
আমাদের application
I appear for the respondent.
Yes, Mr. Nag.
Well, the only
Only point of law.
only point of law on the issue as to whether the proviso of section 12(5) in this particular case applies or not, whether it has been made applicable. Madam, may I only proviso says the only exception if there is an express agreement in writing. That is the proviso says so. Now, what is this expression? The expressed agreement in writing. In my humble submission, it may not be always an agreement.
That is not the point, Mr. Nag. This is the problem. You were not there yesterday.
But there
Now today you are here. Your junior is not here.
no,
This relay race is
No,
not
not really.
appreciated. Point is whether the amendment and the amended provision of 12(5) read with the 7th schedule apply in this case to make the award bad. Because Mr. Yadav, the arbitrator who ultimately pronounced or made and published the award, was appointed in 2016. That is the sole point we are going to hear parties on.
Yes. Now,
there is nothing in writing, no waiver in writing in this case. Nothing has been placed before us, but before that, address us on that, whether at all the provision will apply.
Yes. Now the amended provisions which came into force, if you kindly sees the section 26, it won't apply. The amendment will apply, won't apply to. Kindly sees how the amendment has come into place. Now this section, this is the amendment which came into force 12(5). Now kindly sees
The amendment.
26 once, my lord.
This is the Amendment Act.
Now kindly sees 26.
Of this Amendment Act.
Yes.
Correct. Twenty
Of the amendment
Of the is the
just clarify.
this is a clarification which was given. Kindly sees 26.
আচ্ছা একদম শেষে শিডিউলিং করে
26, my lord, is expert appointment. Is my learned friend, my lord, referring? to that?
No. 26 is there
Of the amendment.
of the Amendment Act, 2015 Act. Nothing contained in this act shall apply to arbitral proceedings commenced in accordance with the provisions of Section 21 of the Principal Act.
Now kindly sees what is Section 21. Section 21 is the reference.
এখানে commencement তো হয়েই গেছে। This is the end of it, as interpreted. নিয়েছেন দেখতে চাস? এই বই আনাও নি? রেখে দিলে হবে কি করে? দুটোই আনিয়েছি, BCCI-ও নিয়েছি, 23টা ওনাকে দাও। আমার না পেলেও চলবে, পড়াশোনা ছেড়ে দিয়েছি। Paragraph revision.
In 11.6, that is also done after the amendment. But because notice was issued, that is the same thing, same logic will apply.
Absolutely. In section 2 is fairly clear. Ekdom.
Also, my lord, one kindly consider one aspect.
Mr. Nag, yes, the section is fairly clear, and this has been, my brother points out, this point has been also dealt with in BCCI and a 2023 case, Sri Vishnu. Are you aware of that?
BCCI, I am aware, my lord.
Yes. Mr. Banerjee, BCCI you are aware of?
The other matter, my lord,
Yes,
saying
Sri
that
Vishnu.
it would
is a-
be prospective and not retrospective.
Sri Vishnu is, take down the reference if you don't have it. 2023, 8 SCC 329. But you don't need to go that far. He will hear you now, because it appears that if an arbitration has commenced in accordance with section 21 notice or 21, then nothing in the 2015 Amendment Act will apply. If that be so, 12.5 goes out. Whether I like it or not, I may not like it personally, I may not like it. But that is irrelevant. And therefore, they are entitled to say that the point you are taking, that Mr. Verma, not Verma,
Yadav.
Yadav was disqualified, that point will not survive. This is now only short point now.
And that is perhaps not the law. The law is that, my lord, if it is prospective, then I'm entitled to take the point.
Look at the Amendment Act. Look at section 26 of the Act. Correct. Correct.
What is that section?
It incorporates when this is a
Hey, এটা দাও তো, at the after the schedule, at the end.
26, section 26 of the amendment. No, it is section 26. Specifying the
Gives me one moment, my lord.
Yes.
Lord, will kindly take my page 366 once, my lord. 366 of the paper.
What is there at 366?
But this is my application which I had filed before the learned arbitrator, which was not considered. That he is not entitled. Although the nomenclature is
Why? Because of 12.5.
nomenclature was that with regard to his fees, but my lord kindly sees, my lord, that the prayer for this as well as the pleadings are there. And my lord, most importantly, kindly sees, my lord, when he has entered reference. That is very important.
He saying so will not matter, Mr. Banerjee.
Only go by the
When
date.
was arbitration? When did it commence in accordance with 21?
Yes, my lord kindly sees that date, and thereafter this, my lord kindly sees
That
when
was
this
the
is coming to amending act coming into effect.
21 notice date was what? Section 21 notice date? That is the date of commencement.
Correct, my lord. He
What is
enters-
that date?
21 notice.
Oh, this has been appointed by the court.
Even that won't do. Sri Vishnu, right? Even that won't do.
Just gives me one moment, my lord. Let me just.
Yes.
সেকশন 21 এর নোটিশটা কবে হবে?
নেই।
করতেই হবে, হয়নি তো কখনো?
সেই উপায় নেই।
But this is
তোকে টাইম দিয়ে দিবি যে একটু আগে উঠে যাই।
well,
খিদে
kindly
পেয়েছে।
keep the date. At least we get the
Mr. Banerjee,
page 70
you better consider and come back.
because there is a judgment, I believe, to the extent, my lord, with regard to section 26 amending act. Because I say, my lord, why? There is a provision, my lord, which has come, my lord, under 11.7 or 11.6, which says of institutional arbitrations. Now, my lord, all high courts, my lord, were appointing institutional arbitrations. There was a matter which I did before Justice Srivastava in his division bench, as his lordship then was, the Chief Justice, my lord, where I showed that, my lord, the amending act has not been notified. In 11, all other provisions were notified except that. So, my lord, Justice, my lord, Srivastava held that, my lord, the institutional frame, my lord, under the act cannot be given arbitration because it has not been yet notified.
That is a
Given to
different.
the Supreme Court and it is held to be correct. Accordingly, my lord, I'll just check. Give me 1 day.
Check. We are giving you time.
Come into effect when?
Check it up. If it has in due time, before the, if it has in due time,
Then I'll have a tough time. এক minute, দাঁড়াও না। Because, my lord, the date is 24th September 2013, but I do recollect, my lord, but judgments, my lord, has set the law, the clock otherwise. I'll just, my lord,
consider
1 day's time.
if the language is fairly clear.
Yes, of
21,
course.
26 language.
My lord, as I said, my lord, in that also language is clear, but, my lord, it was not given effect to.
Find out. Esho,
Yeah.
if necessary, we'll hear you.
Yes.
As of now, we are with you.
Yes, of course. This point, if it is, of course, my lord, it turns around, my lord, I will have to address it.
Mr. Nag, learned senior counsel representing the appellant. Senior counsel, we have said, not senior advocate. uh, has made his submission. Paragraph. Mr. Banerjee, learned senior counsel representing the respondent seeks a little time. Stop. এই কবে দিতে পারবে বলো তো? 12:45 একদিন।
Very short point, yes, ma'am.
12:45. List the matter once again on blank marked 12:45 p.m. কবে? তাহলে তো হবে না। সকালে ফিক্স নেই কবে কিছু দেখুন। মানে কালকে না, পরের বৃহস্পতিবার। Thursday week, Mr. Banerjee. 12:45, mark 12:45 p.m.
Great.
Interesting point.
Interesting point, very short point. The one, my lord, I have raised, which lordship has kept tomorrow. My lord, with regard to, my lord, reconstitution. Lordship said lordship will have to have a coffee and come.
Yes, now also so this is going to help you that maybe, no?
You feel, my lord, but I have a better point because I said it's reconstitution. Constitution, yes, this will help me. This will help me further.
Yes. And he is not your other side in that. রাখো এগুলো, ডাকো, আমরা যাই।
আবার কি হবে?
Lordship, I am very sorry to be mentioning a matter at this.
We are also very sorry.
Lordship, there is some urgency in
What
filing
is
an
it? When
appeal.
was the order passed?
2nd July, Lordship.
Today, what date is today?
I have time as per the Commercial Codes Act. But
Sorry.
Lordship,
Sorry, we had time, but this is not the mentioning time. I would have understood that the order was passed this morning.
Lordship, I'll
No,
apprise
this is
Lordship
not
of
the mentioning time. Call the list. Please follow some degree of discipline. Just don't come and mention anytime you feel like. That's not good.
much obliged. I'll take my chance tomorrow, Lordship.
There's a mentioning time, you know that. Come then, mention.
There was some urgency, Lordship, but I'll take my chance tomorrow. I
Yes, sure, sure. Tako.
My lord, in this matter, I'm appearing for the appellant. We had started the argument in this matter. Today, I'm praying for not today, my lord. My leader, Mr. Jishnu Saha, my lord, is busy in another court and requested me to seek for not today, my lord. Fixed matter today, my lord.
You are the appellant.
My lord, we have started our argument, my lord.
That's all
Once
very
the
well.
My lord had heard us.
Yes.
May I make one submission? They are enjoying a stay, my lord. I am an MSME. My lord would kindly have a look at my lord's last order. My lord, they did not appear. My lord's directions were that they were, if they don't appear, but today they are appearing. That my lord, 2023 onwards, they've been taking time because of the money not coming to me. My lord, I am.
Vishnu Shaha.
My lord. Jishnu Saha.
No, that is not important. Who is appearing is not important. But I'm trying to recall. Shuru korechilo.
My lord has heard us in the matter. We had started our argument. It's a MSME matter, my lord. Will recall.
এটা আবার সেই next বুধবার তো. Sir, let us make it very clear. This is the last time we are adjourning. If you come and tell us again on next Wednesday, for whatever reason, we will not adjourn. There should be somebody else to then hold fort and argue the matter. Is that clear?
My lord.
Once we'll adjourn, come back next Wednesday. Accommodation is sought for on behalf of the appellant. Stop. Paragraph. Learned advocate for the respondent makes a grievance that on various occasions, adjournment has been obtained by the appellant. Stop. The respondent, which is medium,
small, micro, small, and medium enterprise.
which is a micro, small, and medium enterprise, cannot enjoy the fruits of its arbitral award. Paragraph. As the last opportunity, comma, we adjourn this matter till next Wednesday.
My lord will fix a time or retaining its position on the list.
Falls within the category, the MSME category. The respondent is a company falling within the MSME category.
Grateful, my lord.
You're appearing in the matter, you're
Yes,
brief.
yes, my lord.
So prepare yourself, sir. This is a good opportunity. If Mr. Shah is not available, you argue. We'll extend full cooperation to you.
My lord, I will. Thankful, my lord. Item number 12.
I appear for the appellant, your lordship. Lordship, I am being led by senior advocate Ranjan Bachawat, sir. However,
Not
he
come to court.
no, sir. He is unwell. He is under the weather.
Lordship, if I may be permitted to make one submission. I may be permitted to make one submission. This matter pertains to a commercial dispute. So perhaps this has to be transferred to the commercial division of your lordship.
That
It's appearing in the non-commercial list.
Just filed in the non-commercial division or commercial.
lordship, on the earlier date, I had mentioned this same point.
Sir,
before
this is a specially assigned matter. So therefore, when? Not this week. When?
not
What?
this week, next week, your lordship.
Accommodation is sought for on behalf of the appellants on the ground of indisposition of learned senior counsel representing the appellants. Paragraph as requested, comma, let this matter stand adjourned and be listed again on next Wednesday, Kurada.
Much obliged, Lordship.
And that matter.
Jodhpur, we know.
My lord, I appear for the appellants, my lord. My lord, I am led by Mr. Ratnanko Banerjee, my lord. May I begin, my lord?
Yes, let us.
My lord, what fell from your lordships give me an opportunity.
Stand appeal. Why 5 appeals?
Our applications. 2 appeals, 2 each applications.
My lord, I'll tell your lordship, my lord. My lord, one appeal is, my lord, from the order, my lord, by which the executing court allowed the other side, my other side, to take away one property from the execution proceedings filed.
That's the Jodhpur property.
That is one of the properties at Jodhpur. One of the properties. There are other properties situated at
One of the
Jodhpur
properties. Jodhpur,
which
very
are supposed to come to us also. Now, my lord, unfortunately, my lord,
Who has applied for execution? They have applied.
even we have applied, my lord.
Both
This
have
is
applied.
consent award, my lord, between family members.
Reciprocal obligation.
Reciprocal obligations, my lord. Now, my lord, the application that they met before the executing court, my lord, the day it was taken up for hearing, my lord, there was already those regulations in place stating that except for very urgent matters, other matters will not be taken up if the other side seeks an accommodation, because that was during the COVID time. And that time the appellants had engaged Sandersons and Morgans as their advocate on record, and Mr. Oshit Dey was looking after the matters. Now,
Who are the appellants?
I am, my lord. My lord, unfortunately, my lord, Mr. Dey had undergone a bypass, as I clearly remember, and he was on medical leave, and we did not have proper instructions, the counsels. So the client, the appellants, my lord, asked another learned advocate who was looking after some other matters to appear online and make this submission that kindly make it not today on the ground of Mr. Dey. However, my lord, there was some technical problem. He could not make that submission, and without hearing us, my lord, the application was allowed without hearing the point of reciprocal obligations. Now it was incumbent upon them to also place, because the Honorable Supreme Court had directed for both the execution matters to be taken up and heard analogously. So we came back before the executing court and placed our difficulty when the execution applications were taken up next. So the executing court, my lord, on that occasion gave us liberty to file a recalling. During the recalling application, my lord, when it was taken up for hearing, the court appeared to be with us, but found that there was enough representation, because we were saying that we were unable to present our case because of that. And it's there, my lord, it's part of our application, those pleadings. And our recalling application was also rejected without giving us an opportunity to make out a case on merits, that how we'll be prejudiced if this one property in this manner is allowed to be taken out because of those reciprocal obligations. We filed that appeal. So 2 appeals, one order allowing the application and the other order rejecting our.
Very well.
My lord, the first point, my lord, that I'd be urging before this honorable court is that.
So there are 2 appeals and 2 stay applications.
2 appeals, 2 stay applications.
There are 5 matters in the list.
My lord, those 2
are disposed of.
Stays are disposed of.
7 filed by me.
I see.
And 2 sets of application by them to restrain us from moving before the Jodhpur.
So let us see the order allowing them to withdraw a property from their execution application.
My lord.
দাও এটা কোন appeal জিজ্ঞেস করো ভাই? Which item?
My lord, since this appeal, they carried it out to again to Supreme Court, my lord will kindly remember, I can place those orders because these appeals at their instance was allowed. When we first moved this appeal, the stay application, the earlier coordinate bench was of the view, yes, there are reciprocal obligations and you cannot in this manner unilaterally resile after saying that yes, there are reciprocal obligations, admitting there are reciprocal obligations, and the parties have been continuing in that manner, understanding and pursuing the award in execution, saying that there are admitted pending reciprocal obligations on both sides, you cannot resile in this manner, and there was an injunction granted on the first day of the hearing. That is sometime in 22, my lord. The other side, my lord, my learned friend, they urged this court that kindly dispose of the appeal. We will pursue our remedy here, and that's recorded in the order. We are giving our consent. Kindly take up this, kindly allow this appeal vociferously. Because there was only first a stay granted there to hear the appeal. Thereafter, my lord, once the appeal was disposed of at their instance, they came up with a review. And in the review, they said that they could not have met this consent, given this consent. And then they started to cast blame upon this side, that side. Whatever be the case, the court found then that all right, whatever you said is on record. We have made no mistake in recording those submissions. We are again ready to hear out the matter on merits. We'll expunge those consent part given by the learned advocate and we'll hear out the matter. And readmitted the appeal. So, my lord, nobody could have claimed to be aggrieved that the matter is going to be heard out again. They challenged that before the Supreme Court. And the Supreme Court found that what are you challenging? Because they challenged the review. The Supreme Court directed them to come back with the main order. And there they created confusion. Their point, later, those orders are there of the Honorable Supreme Court. Whatever I'm speaking is on record, my lord. And there they created confusion because the Supreme Court was also a little confused at what are you claiming to be aggrieved of when the matter is going to be heard afresh. Supreme Court also directed the matter to be heard afresh. No change.
Let us hear. Let us see. One by one.
My lord, the first order, 27th April 2021, my lord will find at page 190.
Which appeal? This is which?
My lord, this is GA1 because the appeals are being heard out again. This is GA1 in APOT 124.
My lord, GA1s are disposed of. My lord only had called out for the records for my lord's convenience. We had because
that is not correct. That is not correct.
My lord's order. Somebody has to go through the records, my lord. My lord had only requested the department to place your lordship GA1 for the papers. That's all.
My lord, we have to proceed on some record. Since they said that the stay. My lord, this is conundrum.
Now we will take charge. We will ask questions. Both of you will answer. Otherwise, you'll both simultaneously start talking, confusing us even more.
Grateful, my lord.
First order whereby the executing court allowed them to withdraw the Jodhpur property. What is the date of that order?
That is 27th April 2021 at page 190, volume 2 of GA1.
Is that the subject matter of an appeal?
Yes.
Then that would be annexed to the memo?
Yes.
এটা যেটা দিয়েছো তাতে ওই অর্ডারটা নেই ভাই।
APOT 124.
হ্যাঁ দেখাও।
My lord, they should not be saying this the other side because kindly recall Mr. Mitra was leading me, my lord. And
we didn't hear anything.
APOT 124 টা আছে? 124. This is 124. No, এটা 124. Oh, আর 141 টা দেখুন তো একটু। GA1 or in 124, KPOT 124. GA1 টা একটু দেখুন। এটা হ্যাঁ, এটা থেকে পেজ 190 দিয়ে দিন। পেজ 190। 27th April তো, এটা নিন। আর APOT 141 টা একটু মেমোরান্ডামটা বের করে রাখবেন। থ্যাংক ইউ।
না না, এটা হচ্ছে এর আগে একটা যেটাই হয়েছে আর কি, খেতে করে খুলে পাচ্ছে না।
এটা দিয়ে দিন। I've just indicated, my lord. Well, there are two appeals. So 141 and 124.
So 124 is regarding the recalling order.
Recalling order, my lord. Well,
No.
I also get confused. I beg your
Yes.
pardon, my lord. Forgive me. Because the 27th April was filed later.
হ্যাঁ সেই হুম EC 873 is their execution.
Their execution.
Right. Now you applied for, you preferred an appeal against this order,
Yes,
but
ma'am.
before that you applied for
Recalling.
recalling of this order. এবারে ওই অন্য মেমোটা দাও যেটা 124.
The order by which we were granted leave, my lord, that is 6 July. That is at page 163 of our stay application. And the order by which it was not allowed, my lord, it was rejected. That is 26th July.
Okay, that is the material order. Why should we go into
Yes,
the
ma'am.
leave order? एक मिनट। Yes.
My lord, the appeal was disposed of. The stay application was at that time allowed, the earlier bench. Then it odd gall turned around. The court, this earlier court, was of the view that okay, we'll hear out the matter afresh. Those orders, my lord, those orders are my
Why
lord
do we,
part of
why should we consider all those orders? Today, why aren't we hearing the appeals afresh?
for my lord at their instance, my lord. The point is, my lord, reciprocal obligations.
Point is, today two orders are before us as subject matters of challenge in two appeals.
Yes, my lord.
They are your appeals.
Yes, my lord.
So show us that these orders are bad, that's all.
Yes, my lord. On that
We
score, my
don't
lord,
need the history for 100 years. What happened?
my lord, for the
Ultimately,
purpose-
Supreme Court said that you hear the appeals afresh.
for the purpose of reciprocal obligations, my lord. Only on that point.
Reciprocal obligations will appear from the award.
My lord, kindly take that up, my lord. My lord, the award is appearing at page 88 of GA1 in APOT 124. বেটার কপিটা দেখাচ্ছি আমি। হ্যাঁ, ওইগুলো আমি এক এক করে আসছি। রেসিপ্রোকাল অব্লিগেশন দেখাতে গেলে তো আমাকে বোঝাতে হবে যে কি ব্যাপার।
Yes.
The first clause of the award, my lord, page 90. The parties had entered into an arbitration agreement dated 29 December 2012 to refer the disputes to us which arose between the parties with respect to various businesses, properties, assets, companies, and firms belonging to the parties as per Schedule 1 and 2 appended to the said agreement to be adjudicated upon by this tribunal. 2, 3, 4, my lord, I'm skipping for the time being. Kindly come to clause 5. Page 93. The parties to the reference are related to each other and carry on businesses and own properties and assets and control companies and firms jointly. Pursuant to a memorandum of understanding dated July 2008, the parties hereto decided to carry on businesses through their companies and firms on the terms and conditions mentioned in the said memorandum of understanding. However, the said memorandum of understanding could not be given effect to, and the same was given a go by executing the said agreement dated 29 December 2012. The parties executed the said arbitration agreement in order to segregate and or divide and or distribute their businesses, properties, and assets either jointly owned or standing in individual names or in the name of companies or firms controlled by them as early as possible. Immediately after the execution of the said agreement, the parties informed each member of the arbitral tribunal to act in terms of the said agreement and requested the arbitral tribunal to immediately enter into reference. It is, however, important to mention here that 2 members of this arbitral tribunal are related to the parties. This was disclosed and or informed to the parties at the beginning of the reference. In any event, the parties hereto are aware of such relationship of the 2 arbitrators, namely so and so, and the parties executed the said agreement with full knowledge of such relationship. The parties had and or have no objection to the appointment of the said persons to act as arbitrators, and each of the parties gave consent thereof. Thereafter, my lord, kindly look into clause 10. This was, my lord, for the purpose to show, my lord, this was a closely held family dispute decided by other family members. The parties appeared before the tribunal on 1st January 2013 at 5 p.m. and informed the tribunal that they have amicably resolved the disputes and differences. The first party placed before the tribunal a document dated 1st January 2013, signed by all the parties, which was taken on record. On perusal of the said document dated 1st January 2013, by which the parties had amicably resolved the disputes and had mutually agreed on division of various businesses, properties, assets, companies, and firms, the tribunal was appraised and learned about the agreed division and distribution of various businesses, properties, and assets, and companies and firms between the parties. The parties further appraised the tribunal about few other entities. My lord, I'm not troubling with that. Thereafter, my lord, the last paragraph on that page. The parties further informed the tribunal that as regards cash, jewelries, and other personal belongings, the parties have mutually decided that each parties would retain cash, jewelries, etc., etc. 11, my lord, clause 11. Inasmuch as the parties to the reference having agreed to a mutual settlement of various joint businesses, properties, assets, companies, and firms as recorded in the document dated 1st January 2013 and as further agreed during the course of arbitration sitting on 1st January 2013, the parties to the reference requested the tribunal to record such settlement and to pass an award in terms thereof. In view of the settlement arrived at between the parties as recorded in the said document dated 1st January 2013 and as further agreed during the course of meeting on 1st January 2013, the arbitral tribunal passes the award in terms thereof, which are as follows. The properties and or companies and or firms under heading Suresh Kumar Jain Group, the other side, my lord, will exclusively belong to the party of the first part and or his nominees, and those under heading Madan Lal Jain Group will exclusively belong to the party of the other part. My lord, I am representing them. As set out herein below and subject to the terms and conditions and in the manner mentioned hereinafter. The absolute ownership and control of the company or companies, firms or properties will be done in case of company by transfer of shares owned and or lying in the name of either the first party and or his nominees or the other party or their nominees to that party or his or their nominees who is or are exclusively entitled to own and control the companies under the award. The outgoing party or their nominee.
These are the modalities, usual modalities. We have read
My
that.
lord.
Yes. Then the list of assets, companies, etc. It's all there.
No, my lord. Kindly bear with me. Before that, my lord, kindly look into না একটু কাস্টোডিয়ানের ইয়েটা দেখাতে হবে kindly look into clause 14 The parties will take necessary. That is, my lord, at page.
He is 116. Tell us.
Yes, 116. The parties will take necessary steps to have the guarantees given by the party not allotted the company either individually and or through their companies released within a period of 9 months from the date of passing of this award. In case if any of the parties fail and neglect to have the guarantees released as he or they are obliged to under this award, the defaulting party will not be entitled to get any documents or papers with regard to allotments made in favor of such defaulting party till such time the defaulting party gets the guarantee released in terms of this award. In addition to not being eligible to get the documents and or papers, the defaulting party will also be liable to pay a sum of rupees 2,50,000 only for each day of default to the party who is not at fault till the time the default continues by the defaulting party. My lord, this is the part, my lord, that we have made our execution application, that there are a number of defaults committed by them. Kindly take up the next part, because who decides upon this default?
So
that
put the property in question, in whose name does that property stand today?
for the company which has gone to them, kindly take that up.
You can execute, enforce the rights that you have under the award. They can execute or enforce the rights that they have under the award. His right is your obligation. Your right is his obligation. Do it.
The question comes, my lord, about the defaults that they made. My lord, they had challenged the award for 2 years. The question, my lord, is on that. And my lord, this issue is no more res integra, my lord. This has been held, my lord. My lord, kindly take clause 15. Because, my lord, this is the exercise, my lord, that is being carried out by the executing court right now. That what are the defaults committed? It is better, my lord, that I place clause 15 once. The tribunal appoints Mr. Kamlesh Sogani, chartered accountant, as custodian of various documents, deeds.
That is they. The subject matter of their execution.
No, देखिए.
It was 38.
Now, my lord, it may appear, my lord, that they are entitled to that property. I am entitled to this property. You take away that property, I take away this. Not so, my lord. All these companies and businesses, there are about 25 companies involved. Some companies had assets. Individual members had assets. They bought everything into the hodgepodge. And then they decided that since this is a consent award, we are not going to arbitrate in the manner to cut short the matter. We'll appoint somebody as custodian. Whatever is set out in the award, in that manner, you have to resign from the companies. Each member have to resign from the company, have to give that resignation deposited there with the custodian, and do so many other things, my lord, which I was taking your lordship through. Not just resignation, handing over share scripts.
Small thing I'm still unable to understand. A party files an execution application trying to execute an award or whatever decree against certain properties. One fine morning, he is advised or he has this divine realization, no, I will not execute against property A here. I will withdraw that from this execution application. Who can stop him?
Nobody can, my lord.
This
It's
is
not
what we are
like that,
trying
my
to
lord.
do.
Forgive me, my lord. It's my fault that I am unable to present the
You
case.
do whatever you like to enforce your rights. Who stops you?
I cannot, my lord. If they are allowed to take away that property, they have to answer for the other properties.
Why? Because
Which
you are in
the
possession
award-
of that property.
Yes, my lord. Which the
You
award.
have a car showroom there.
Yes, my lord.
No,
There are other.
actually, we want to know.
Yes, my lord. There is a car showroom for 4 years. Now, the initial term was, my lord, 4 years. But they did not make over the other properties which I was supposed to get. And the award says that till you make over all these documents to the custodian, then, my lord, what is the purpose of clause 19?
Go and argue these points before the executing court.
My lord, we have. And we were also successful in other executing courts that these are common questions of law, whether they have discharged their pending obligations under the award. Have they handed over all the documents that were required under the award to the custodian? Have they discharged? These, my lord,
By
that's.
the impugned order, nothing has been executed. No execution order has
But
been
my lord,
passed.
I will be thrown out of that property.
Why? Why can't you defend that?
My lord, because that has been allowed to be taken out from here.
They want to execute against this property in the Jodhpur court.
In the Jodhpur
What
court.
stops you from contesting that?
I am contesting, my lord.
Then
But
what
there
is
will
the scope of this
there
appeal?
will be conflicting issues, my lord.
There'll be
My lord,
nothing.
I'll tell you, my lord, the title documents relating to that property, my lord, the Jodhpur property, they have been directed to be handed over with the registered original site. Like that, there are other property documents also lying with this court. Tomorrow, they are going to go before the Jodhpur court and say that I'm entitled to that document. Let that document be read over.
Speculative? Wholly speculative?
No, my lord, that is their application. That is their
Contest it.
application.
If you have a right in law to resist their claim, resist it. Who stops you? We see nothing wrong with these two orders, Vishwanto. The more you argue, the costs will go up. That's all. We are telling you very frankly. Take instruction. Take instruction. Nothing has been done by these two orders which may prejudice you. Protect your right. Resist their claim. Tell the executing court that no execution order should be passed in their favor because they have not performed their part of the deal. Where will I go with my car showroom if they are not handing over the property that they are supposed to? Tell the executing court that. Why before us?
That they are contesting two civil division application filed before the Honorable High Court at Rajasthan. They are contesting, hotly contested.
Either, we leave it to you. You argue, we'll then pass a judgment on merit, or we still give you an option to withdraw.
My lord, kindly give me a day's time, my lord, to come back, my lord.
Your instructing advocate on record is here.
I am led by Mr. Ratnanko Banerjee, my lord.
This is
kindly
not
give me a day's
fair.
time.
You have argued for half an hour.
My lord,
And-
I have tried to, my lord, put forward the case, my lord. I'm going somewhere amiss, my lord, particularly
not
clause
going-
19, because, my
You are
lord, we
not
are on
going
that
amiss
question.
anywhere. You're not going amiss anywhere. We can assure you.
Because, my lord, that was the stand that the reciprocal obligations are there until and unless you discharge all your obligations under the award.
Resist the execution, madam. This is what we are
My lord,
saying.
we are, my lord. My
Then-
lord. But that is leading to multiplicity of proceedings. আমারও হচ্ছে
Law provides, Sundaram Finance provides.
Kindly, my lord, let me come back, my lord, because on this reciprocal obligations, my lord,
Same thing fallen from your lordship.
because my lord, the courts have been consistently with us that yes, there are reciprocal obligations. The custodian, whatever he has done, he has not ensured.
Are we saying there isn't or there is? We are not saying anything. We leave it to you and them to fight it out before the executing court.
Fighting it out there.
Then, my lord, on this point, my lord, that we can and it will not be sufficiently protected, my lord. There will be some conflict of interest,
They
my
can't
lord.
take gundas and throw you out. They will have to go through process of law.
Hope so, my lord.
What do you mean hope so? No, don't play with words. Obviously, that is why they are before the court.
My lord, that was not their conduct, my lord. There are orders, my lord, of this court.
Order, because same thing had fallen from your lord when Mr. Sharma had argued for the entire day. They said that they will.
No, he did not entire, my lord, entire day.
Like this,
My lord,
going on, Milad.
I have placed.
Argue.
Yes, kindly let her complete, Milad.
Complete.
Let her complete. Because Milad, it will continue, Milad.
Yes, my lord. We have also granted them many concessions, my lord, from our side. We have not stood in their way.
Very
Milord, kindly give me 1 day's time, because my lord, I have not been able to convince my lords on that issue, my lord.
Mr. Banerjee to re-argue this matter.
No, my lord, on that point only, my lord.
Change of
Come back tomorrow. এই দেখো তো কালকে আমি জানি অ্যাপেলের সাইড ফিক্স করা আছে সব
My lord,
same thing happened with Mr. Sharma.
Mr. Dasgupta,
From your lordship, same thing. They said that we'll take instructions.
সেটা তো বললাম
My lord,
all the
then
time,
they stopped
একই।
appearing every day. I am sole person who had been appearing before lordship every day.
When did we stop appearing?
This is the conduct.
Mr. Dasgupta, we have expressed our mind. They still want to argue. The consequences will follow. Yes.
My lord, can it be taken up, my lord, on 13th, my lord?
14th,
No.
some difficulty.
No,
Why?
for the simple reason that we have applied our mind.
Just inform
We have applied our mind. We are going to forget everything
NCLT চলে গেছে।
by the 13th.
High Court ছেড়ে NCLT গেছে, NCLT গেছে। More important, let him be in NCLT. Milord will dispose it of, Milord. No point, Milord.
Well, tomorrow 10:30. Tomorrow at 10:30 before appellate side.
Yes, well.
কি order করবো?
Milord, kindly.
We have heard learned counsel for the appellants in APOT 124 of 2021 and APOT 141 of 2021, comma, at some length. Paragraph on the request of learned counsel for the appellants, comma, let this matter stand adjourned and be listed again, kalke date the marked 10:30 p.m., comma, to be heard, to be heard before the appellate side matters. এত ভয় পাচ্ছেন কেন? তাহলে আলাদাই করে দাও, একটা APOT 141 বললো, একটা 124 বললো।
Item 18, my lord, I appear for the respondent number.
এই
कौन आ रहा है? Gopal Ma. Supporting the plaintiff.
yes, that's
My lord, I appear for the respondent number 8.
1819.
Yes. My lord,
Yes, Lamartine.
Lamartine, madam. My lord, I am supporting the appellants, my lord.
I believe on the last occasion, your lordship went through the impugned order, and your lordships were of the view that the finding is not, considering the submissions made, my lord, the finding was not justified.
When was that? I have
Yes.
no recollection.
But may I just place, may I place the impugned order once, my lord?
What your lordship observed is recorded in your lordship's.
देखिए भाई की last order.
Last order.
28th June.
And
Who is for the appellant? You are led by Mr. Shah, Jishnu
no,
Shah.
I'm led by Mr. Bachawat, my lord. I'm for the respondent number 8. I believe Mr. Shah has already made his submissions, my lord.
No, he is not concluded. I don't think he is concluded.
Made his submission, not concluded.
Yes, yes.
But your lordship's desire.
Why have you come to court?
Lord, I have not come to court.
Good. He's not well. He's not well.
But I'm being led by Mr. Bachawat, who's for the respondent number 8.
Yes, but the appellant is not here.
My lord, I'm appearing for the appellant. I beg to appear, my lord. My lord, I was led by I'm led by Mr. Jishnu Shah, my lord. We were making our submissions, my lord. I was only humbly beseeching, my lord, if your lordship would be pleased to fix, my lord, any particular date or time, my lord, when my lord, Mr. Shah would come and make his
Yesterday at 12 p.m.
My lord, I beg your lordship's pardon for appearing online, my lord. If your lordships could accommodate us, my lord, any
Yes,
date.
we are. Yesterday at 12 p.m. Date and time you asked for. Not possible. Sorry, sir. You want an adjournment? We'll adjourn the matter.
My lord, I will just indicate in one more minute, my lord, what happened, transpired on the last occasion, my lord. Mr.
Order last din orderটা দিয়েছিলে?
No, 20th
My
June.
lords had called for a report from the registrar, my lord.
I see.
Yes. That report, if filed, may be circulated, so that we can come back prepared with the.
Oh, pendency of the suit.
Yes, so, my lord. So, my lord.
Right. Confusion. Hey, register report দিয়েছে? We'll circulate this report. Consider all of you.
My lord.
এই শোনো না, ওই ওল্ড ইকুইটি সুটের কোনো রেকর্ডস এসছে? The records are still there. আমি ছোবো না। Circulate this.
But this is 1967. Old equity suit is 1800. Well, the only thing is this the 2602 1967 or the old equity suit which is of 1800s? That is the old equity suit, which is the original
1967.
1967. This is not the old equity suit. Subject to correction.
No, we asked for records of both.
So the 1967 is here.
1888 records are
because that is the suit under which the scheme was framed, where all the 12 ex officio members.
Not traceable. Not traceable. That's the report. Consider the report. Come back. Anyway, it's being adjourned. The report submitted by the registrar, original side, in terms of our order dated June 20, 2025, be circulated amongst learned advocates for the parties. এই কি করে করবে কৌশিক? এটা ওরা পাবেন কি করে?
The advocate on records may take a right to the registrant.
by
No,
the
we-
registrar, by
No,
the
we, no, we can photocopy in presence of your lordship's office, my lord. That will be much faster, my lord. We can photocopy in presence of the your
by
lordship's
the
office.
registrar corona be circulated among the learned advocates for the party. Stop. Learned advocate for the appellant. Who is your advocate on record?
Well,
Sorry, you are not the appellant.
My lord, I am the advocate on record in item number 18.
For,
We'll take it. We'll take it. He's the
you are the advocate on record.
Item number 19. Item number 19.
Very well. Learned advocate on record for the appellant in
APDT 7.
APDT
7.
7 of 2025 may obtain Xerox copies, may obtain photocopies of the report in the presence of our court officer and circulate the same amongst learned advocates for the other parties. List the matter once again next Wednesday. Tarikta diye dao.
next one is Taro. Ah, Taro, he's there. Yeah. I'm grateful.
Very grateful.
Grateful, my lords. Much obliged.
My lord, this is that matter.
Yes, yes.
Yes, my lord.
You are for LMJ?
Yes, my lord, copy was served by email. We are not taking any time. My lord, just remember two things. The Honorable Supreme Court said, my lord, if it is possible, then indicate the customs dues and the port dues, both customs and port dues. Now, my lord, the question is, it has to be valued, and a reserve price has to be fixed on the basis of the valuation. Now, thereafter, my lord, the sale reserve price would be fixed. So your lordship wanted to know how much approximate idea is the port dues and the customs dues. To that, my lord, we filed an affidavit saying that these are the customs due. Out of that, about 6,000 duty has already been paid. We have indicated that. And this is approximately what the customs duty might be for the balance goods. My lord, this is what we have said. The other portion, your lordship wanted to know how much are the port dues. Now, my lord, port dues means, my lord, lordship remembers that in the Supreme Court order, LMJ themselves said, and it is recorded in an order of 2017, that the port dues are over rupees 2 crores. 2 crores. It's recorded. Submission of LMJ. On that basis, the entire order was stayed. It was a submission made by LMJ that the port dues are over 2 crores. Now, today, I have filed a particular chart saying, my lord, every bills cannot be calculated. So we have given a chart saying that the dues are about 5 crore 45. Out of 5 crore 45, I have said that up to 23, the port has raised bills. Beyond, from the period 23, when you want to clear it, they will raise the bills. So on the basis of estimation as to what the past dues, we are applying, this is the approximate past dues. This is the past dues. The figure indicated is 5 crore 45. I look at it this way. 2012 to 2017, they said, agreed, it was above 2 crores. So I said 2 crores. 17 plus 5 comes to 22. 22. I add another 2 crores. 4 crores. And my lord, we are in 25.
It's roughly, my lord, 1 crore 45. I think they want, no, I have to produce all bills, and this is what has been going on. The receiver, my lord, special officer will examine and say, why is this bill so much? Why have you said this much, so much? That is not the order of the Supreme Court. Another point which has been taken, my lord, Bothra shipping is my sister concern. The go down is in the name, my lord, of Bothra shipping. From the port. So the bills raised by the port are on Bothra shipping. Bothra shipping. So said, why are you saying that? I mean, bills are put that you are Sharat Chatterjee. I'm the clearing agent. But my sister concern, the bills are being raised by the port. So these are the two types of defense.
What do you mean by sister concern?
Well, Mr. Bothra is the owner of Sharat Chatterjee, Mr. Bothra. So Bothra is a sister concern. He has taken it on rent, and therefore, my lord, the bills are on him. The go down is one. Go down is one. It is owned by that person, entity.
In your affidavit, have you disclosed any figure? What could be the port due or?
Their control.
Yes.
Entire plot.
So
Them was an expectation to verify what they are producing before the learned special officer, the bills, because they either do not relate to the goods, or they do not relate to the plot, or they are by some other company.
Anyway, madam, today, whatever the amount we due to customs or port, the coke has to be sold. The coke has to be sold, 10,000 metric tons of coke. For that, a latest current valuation needs to be done.
That is all.
So, as of today, do you recommend the valuer? Should we go for the gentleman who did it earlier?
My lord, we are, my lord, not in any way aggrieved by the valuer. What we are aggrieved is by their bills. They have not been verified.
That is not the subject matter of the sale.
That's right.
To be, my lord.
That will be adjudicated later.
If it is adjudicated, to be adjudicated, my lord.
You filed an affidavit giving
I filed
the earlier valuation reports?
Yes.
Hey,
Earlier valuation.
No. This was
separately handed over.
Handed over
Very well.
separately.
Custody has been, my lord, identified, my lord. The port charges have not.
How much roughly customs?
Customs duty can never be identified. And I told your lordship why.
6,000 MT you have said already.
Has already been paid. That is.
We have no objection to that. It's the port charges for the plot rentals.
My lord, that is not the
sold first.
But, my lord, nothing on record.
All this has to be adjudicated.
My lord, later on, after the goods are sold.
My lord, but the Supreme Court directs that they have to be indicated.
No, they do not.
If possible. To the extent possible, we'll say it is becoming impossible.
If possible. But some credibility must be there to the figures.
I have told your lordship, they themselves got the sale knocked off by saying dues of port are of over rupees 2 crores in 2017.
They have not produced
I am
one document in support of their claim. We were expecting, my lord, they will.
They say this.
Bring it on record.
Look at the order of the Supreme Court.
Yes, kindly show.
I am showing. It was indicated you were not there at that day.
No, I was there. I was there. Page 12.
My lord, kindly see
Running page number 46.
running page number 46 of the application. What are the port charges?
2,000 per metric ton.
My lord, port charges, column C.
Page 47. My lord,
My lord,
the sale is taking place to secure the claim of LMJ. The respondent number 2.
My lord, not secured the claim of LMJ.
That is the appeal court's order.
My lord, may I? My lord, page 46. Will your lordship? My lord, there were two valuers, My lord, one gentleman, J.B. Boda,
The last valuation report
is Alex
22nd
Stewart.
February 24.
Yes.
22nd
Well,
February
that
24.
was that was
49.
phenomenally high. That was phenomenally high. My lord, the earlier valuer, J.B. Boda, my lord, both these people have their offices in Visakhapatnam. That is why they were chosen. My lord, it is for your lordship to my lord, if your lordship is thinking of the previous my lord, may I give you a chart on which day what valuation was given? I made a one-page chart. My lord, if your lordship is thinking of appointing of any of the two previous valuers, my lord, I would, if your lordship, not that I can reckon, I mean, out of the two, my lord, I think J.B. Boda, who has given, because pursuant to which the earlier sale had taken place, in fact, will be a better option. Because Alex Stewart, my lord, is given a phenomenally high, my lord, and doesn't even include whether, my lord, it includes customs and port charges.
That sale which was set aside.
My lord, page 46. If your lordship kindly comes to the petition, my lord, if your lordship is seeing page 46 of the running, my lord, my lord, are you
24 একবার 22 আর বোধা করেছে 21.
my lord, if your lordship is seeing just page 40.
তাহলে তো
My lord, may I indicate what is the difference? J.B. Boda way back in 2017 said about 14,000 per metric
Suppose
ton.
we find J.B. Boda did valuation twice in 2016 and 2021.
2021.
And Alex Stewart did twice in 2022 and 2024. J.B. Boda's valuation didn't find favor with Supreme Court.
No, once it didn't find favor. Next time
we will appoint Alex Stewart. We will appoint Alex Stewart.
my lord, if you my lord,
You should be having no say there.
no, I will have.
So don't.
No, not on a different point, my lord.
Yes.
If please come to page 46 of the petition. My lord, neither JP, that's why I said if your lordship knows anyone, you please appoint. But my lord, kindly see calculations which are given by appellant, that is LMJ. Are you on page 46? LMJ, before the Supreme Court, charges, taxes, which are not refuted by respondent are as under.
Who's that? Respondent number 5. Who is that?
That is the purchaser. That is
There are allegations that that's a conclusive suit.
my lord, kindly come to see. This is the charges. Port charges approx. My lord, port charges approx. This is suggested by them. They agree. Is 2,000 per metric ton. And my lord, into 10,000 comes to 2 crores. So, my lord, now please come to the last portion of the order. Why it was set aside. We therefore allow to set aside the order to direct valuation so that public auction's clear stipulation that reserve price is exclusive of taxes. Then it is said, if it is possible, to ascertain exact charges and taxes, those may be indicated so that indicator have a clear picture while making the bids. How it will have, Millard, my lord, that is why I said no one is adjudicating this. Up to 2017, 5 years, 2 crores. My lord, another 5 years will be 4 crores. And my lord, after 22 to 25, I'm taking. My lord, that is how unfortunately, the port charges work.
Mr. Bose, madam, those things will be relevant when the sale notice will be issued.
My lord, absolutely right.
So
because
today, for valuation, these are not relevant.
no, it is not. Only let them indicate in the valuate that whatever price you valuation, it does not.
Exclusive of customs dues, port dues. That's all.
Right.
Kesho bhai.
The order is on sale for 10,000 only. So let him not bother about rest. He is to take away. That is the order of the. So we are only concerned with 10,000.
Page 29, there is a direction of I'm supposed to be 1400.
Again, order gulo.
My lord, the direction for sale is only for 10,000.
The sale, logic of quantum which is pending there, which is there in the custodial of the Bharat Chatterjee lordship. What is the quantum there? Because I'm sorry, lordship will comes to page 33. There is a direction that the 1465 metric ton has to be given to me.
My lord will kindly consider that order, the first appeal court's order, by which the sale was directed.
My lord.
That they are not placing.
My lord. No, I can't place it for 3 occasions. I can go on placing.
Read
page 26, last portion.
Read orders dated June 12, 2025, June 26, 2025. July 17, 2025. And July 17. Paragraph. There may be some confusion as to the amount on amount payable as customs duty or the amount of port charges, but there is no confusion that the concerned 10,000 MT of coke needs to be valued once again so that a current valuation report is available to enable issuance of a fresh notice of sale by public auction. Stop. Paragraph. We find from the records that JB Boda insurance surveyors and loss assessors, page 23 Private Limited, was engaged twice, once in 2016 and again in 2021, to value the concerned coke. Stop. Alex Stewart, International, India, ETA page 27. India Private Limited was engaged twice, once in 2022 and once in 2024 for valuing the same coke. Paragraph. We are of the opinion that Alex Stewart, International, India Private Limited, should be engaged by the special officer.
Well, it's for your lordship, or you want another person, my lord. I am even willing to pay for the new, if a new person is appointed, I am even willing, to pay the entire, because it was to be shared 50-50 by both of them. The official liquidator will not, my lord, as priority, I will pay. These are my client's instructions.
Mr. Mukherjee, you do it immediately. To be engaged by the special officer. Ki bollam? That Alex Stewart, etc. By the special officer for obtaining a current valuation report in respect of the concerned coke. How long it should take? 10 to 15 days. No, formalities, Manita. He knows nothing. How long it should take?
I'm led by Mr. Banerjee.
How long it should take valuation? We are directing a.
I'm told that part of it was what the volumetric assessment was done. So that 3 weeks not gives them at most.
3 weeks. Report, stop. The value indicated shall be exclusive of the port charges and the customs tax that may be due.
Exclusive.
Not inclusive.
Not so
exclusive of. Which will be payable separately. Which will be payable separately. Paragraph. List this matter 3 weeks hence. Remuneration, who will pay the charges? You have funds with you?
No, there is no fund. There initially only 50% to be shared by the official liquidator and them. Now, my lord, as I said, I am willing, because if it comes clarity from
very well. The cost of valuation.
Yes.
The cost of valuation will be borne by you are respondent number 1.
Applicant
oblique respondent number 1 at the first instance.
May Lord, kindly only provide that they will be recovered from the as priority.
At the first instance?
At the
first instance.
May Lord, I am willing, because it's my.
Yes.
So that's a dispute with regard to Lord.
Very well.
And,
10 minutes उठे जो. You want to share the cost?
Remuneration.
Of valuation.
Miller, that's the order. That's the order. But I am saying because official liquidator has walked out.
Cost of valuation to be shared by the applicant oblique respondent number 1 and respondent number 2 at the first instance.
Miller, can I, with whether it'll unnecessary? I'm willing. If it's remuneration, my clients have objection. If it's the same special officer. But if your lordship directs, that's something.
No, but past remuneration has
always to be shared by them and
till date has it been paid? I don't know. Is it a monthly remuneration?
No. One-time remuneration to be there.
After that,
that was the order of 2015.
How much was paid?
50,000.
Paragraph. We are told that the special officer was paid an initial remuneration of rupees 50,000
by them, my lord.
By
to be shared.
Respondent number 2.
2 and the
which was shared by the respondent number 2 and the appellant. Let the special officer be paid a further remuneration of rupees 50,000. You share it.
At the first
instance. If your lordship, as per direction, if you
to be shared by the applicant oblique respondent number 1 and the respondent number 2 to be shared equally. No,
there is no. My clients are not obliged to
respondent number 2 at the first instance.
But your lordship they wanted a change. But your lordship directs, that's a different issue.
At this stage, let us see.
No, if it's lost coming from the court, I said, but that's my client's instruction.
3 weeks since later the other.
Your lordship.
Uchish. He আসে
And Miller, your lordship had said only valuation of the goods, right?
Valuation.
No, he was talking about volumetric again.
Valuation.
Yes. Well,
Lord, I'm very sorry, my lord. In the other matter, my lord, I was addressing court 4.
No, she very ably assisted us. We are just
for that, my lord. I was supposed to start.
we have expressed our mind, Mr. Banerjee. Tomorrow we have kept it at 10:30. We have indicated our mind. Your junior should apprise you, brief you.
Depending on that, my lord, whether it will be a very uphill task or, my lord, a very
downhill task.
Downhill task.
No, we have almost, because we have heard her fully.
My lord, I'm again, my lord, very sorry, my lord. Mr. Sharma is going to take me to task because he's the one he said. He said, will you come
Mr. Banerjee, Mr. Sharma tried to convince us on one occasion. He failed.
Then, my lord, I have
right.
Mr. Sharma and my learned friend has
because we don't see that any prejudice has been caused to your client. Absolutely resist whatever claim they are making before the executing court.
I will just want to make very short submissions. Yes, because I thought, my lord, perhaps, my lord, one point.
Make short submission, please.
Yes.
Then we will pass the order.
After, my lord, consideration of that submission.
Yes. Absolutely.
Well, lordship has kept the valuation, so please make it partnered.
No.
Okay. Then, my lord, kindly say at the first instance, payment or remuneration without prejudice or something, it will be come from the side.
The issue of reimbursement of the cost of valuation and remuneration that is to be paid to the special officer shall be decided later. Issue of that is what it means. He wanted a better clarification.
Like reciprocal obligation.
That's the first.
You will argue na tomorrow.
Reciprocal.
For some of the responses.
Lordship's last occasion, Lordships was pleased to record that the substitution application needs to be filed with respect to carrying out the recording of the death of some of the respondents. Lordship, that application is ready.
You are for whom?
For the appellant.
Yes.
Now, the application is ready, however, not filed. I'm seeking some more time. In the meantime, we shall complete the application. Lordship,
Learned advocate for the appellant says that the substitution application is ready, but not yet filed. Stop on her request, let this matter stand adjourned.
10 days. 10 days, my lord.
And be listed again Monday week.
I'm grateful.
Thank you.
ওইটা তো সেই বড় এটা বুঝেছি You are aware that we are rising at 3:25.
We all are here for that.
6 minutes if you like, whatever.
তোমাদের appeal-টা আগে।
Your appeal?
We have two appeals.
Yes.
APO 486 is Mr. Mitros.
Dr. Tajul Mulk is you.
I am representing APO 489 and 486 is theirs.
All right.
So technically theirs is.
So
I opened this case pilot on an earlier
property in Dhanbad.
It was sold. Special administrator was appointed over the matter, entire estate of this
Chatterjee folk, including Hillgers. Now, this property belonged to Hillgers. Now, they say, my lord, that they purchased this property from, my lord, Hillgers or, my lord. Now, this alleged sale had taken place, my lord, at a time when, my lord, there was an order of injunction and, my lord, the property was in the custody or, my lord, it may not be in actual physical custody, but, my lord, custody or administration.
Administrator court appointed. So as they say, custodia legis or whatever.
It was sold in auction. My client purchased it. Special officer went to hand over possession. And we say that the possession was handed over. They are disputing. They are saying that they are the owners. Now
These are appeals from decree. No. Appeals from order.
Order.
Passed in execution. No. Let us have a look at the appeal that you have preferred.
But kindly come to the ballot. I will tell you, Lordship, ballot. Kindly come to ballot page 148A of ballot the appeal.
There are 712 respondents.
The depositors are there, my lord. I appear on behalf of the depositors.
Oh.
Depositors, my lord. They are the most.
We might know some of them possibly.
Kindly come to page 148A of ballot the appeal by movement traders.
Is that the impugned order?
No, that is ballot the application which was made.
No. It a road. Mr. Mitro, subject to your convenience, every day this matter is taken up for 5 minutes and then Friday as a special case. No, Friday difficult.
Very well. Friday at any time.
No, we'll keep it at the top, towards the top. After applications এমন ভাবে দাও ওটা স্পেশালি ফিক্স করে after the new applications নোট করে দিও কি আছে এটা কি come back let us
করছে বলো
So can you hear us? Are we
Hello.
audible?
Lord, am I audible? That was my question.
Yes, yes. Yes, yes.
Lord, last occasion, on behalf of the contemners, Mr. Bandyopadhyay had concluded his submission.
Yes.
And supporting set or the others, they have adopted the submission of Mr. Bandyopadhyay. Now, my Lord, what I submit at the outset is, my Lord, once the rule is issued, my Lord, I am the informer. I am neither the petitioner nor a party otherwise. I have informed the court that this has happened. Therefore, matter is now between the contemptor and the court. And I can make submissions only if the court requires any assistance from my end. Otherwise, not. So that is the position of law according to me. Now, if your lordships feel that my submission will be of any assistance to your lordships, then I can try to assist your lordships.
Mr. Sengupta, we would like to require your take on this, on the technical maintainability point taken by Mr. Bandyopadhyay.
Yes.
And also on the involvement of respondent number 8, because the other respondents virtually they have apologized and said the context, maintainability and involvement of respondent number 8. If you can throw some light on that.
Grateful to your lordship, grateful to your lordship. So far as maintainability is concerned, I understand Mr. Bandyopadhyay has argued that only a rule can be assigned to this bench. This rule has not been issued by the bench of Chief Justice, and therefore this is really of no avail. I believe this is the maintainability point.
Yes, and basically he also submitted that this bench had no jurisdiction to issue the rule.
That's right. I make my submission on this. Kindly have a look at, before showing the provisions of law, I would like to remind your lordship of the very well-known proposition that rules of procedure are intended to be a handmaid in the administration of justice. And if a reading or an interpretation defeats justice, frustrates justice, then such a construction is not to be adopted. Because the ultimate result will be the injustice which law tries to avoid. Now, if your lordships, when your lordships are dealing with this case, it's of great moment because some people are trying to undermine the dignity and majesty of the court. One, by humiliating one sitting judge of this court in respect of a matter where these persons were parties. And what we have done is simply we have brought it to the notice of the court. My lord will kindly see, this is the situation. The court said, two advocates mentioned, court said, well, we cannot do anything unless you get it registered. Go there and have it registered. Then come to us. And that was an order of the division bench. Then, after registration, again the advocates went and said, all right, I send it to this bench. Now we have two things. Whether this could be done before issuance of rule, it's number one. And number two is, Chief Justice is the master of the roster. Whatever matter the Chief Justice feels right can be assigned to any bench. And that's a general power. Kindly pardon me by repeating, this is a general power. And the provision of the contempt of court rules cannot take away the general power. The general power is always there. The Chief Justice can assign any matter to any bench and any court. Let I give you an example. It is common understanding that when a civil contempt matter is placed before the court, it is a judge whose order violation is complained of. In that case, that particular honorable judge hears it. In one case, Lord, the High Court, Chief Justice of High Court, assigned it to some other learned judge. Matter was taken up to Supreme Court. Supreme Court said there is nothing wrong in it. After all, he is the master of the roster. Therefore, this can always be done under general law. Now let us see whether the specific rule makes any difference in the position. Kindly come to Rule 15, on which reliance has been placed by Mr. Bandyopadhyay.
Rule or section or rule, Mr.
Rule. I'm sorry. Section.
Contempt of Courts Act. Rule 2, Rule 16, 17, 18 সব দেখিয়েছিল।
I shall go to
Section 15 বলেছিল, even assuming there is jurisdiction, suo motu cognizance could not have been taken under Section 15 in the manner it has been taken.
Yes. Well, answer is very simple. Your Lordship's bench has been assigned to hear this by the Honorable the Chief Justice. Your Lordships are not being able to hear me.
Yes. Now we can. Suddenly you had disappeared from the television screen.
Oh, Lord, my misfortune. That in spite of
something wrong at this end. Yes,
Now,
Section 15.
Kindly see, in the case of a criminal contempt, other than a contempt referred to in Section 14, the Supreme Court or the High Court may take action on its own motion or on a motion made by the Advocate General, any other person with the consent of the Advocate General, or in relation to the High Court or Union Territory. Such law officer as central government may by notification the official get to specify in this behalf, or any other person with the consent in writing of such law officer. Now, my first submission of this is it the enabling power giving High Court the jurisdiction? My respectful submission is no, because the power comes from the Constitution itself. Constitution has clothed the Supreme Court and High Court as courts of record with the powers to punish for contempt. That is not derived from the Contempt of Court Act. If that is not derived from this Act, a provision of this Act cannot curtail the general power that has been given to the High Court on this. Now, question is, what does the Supreme Court say? On a number of matters, the Supreme Court had occasion to deal with such situation. Supreme Court said it's up to the High Court. It's up to the High Court. Because High Court could do it, suo motu. Question is not whether the Chief Justice could assign this to someone else. The construction that has been sought to be put under to Rule 15, I showed Section 15 only to emphasize the power is not derived from Section 15. Power is derived from the Constitution. And no law can curtail in any manner whatsoever the power conferred by the Constitution. A reading of the Act in this fashion only leads to the conclusion that, well, the power otherwise the Constitution vests in the High Court is circumscribed by this provision, and no other way is permissible. Now we'll read along with this Rule 15.
Hey.
I'm sorry.
Kolkata High Court আছে তোর কাছে? Kolkata High Court contempt rules.
Your Lordship will get it in the book of Mr. Paul, where all the High Court rules are annexed and our High Court rule is there.
আচ্ছা। তোর আছে ওই জিনিসটা এইটাই অর্ডার দিচ্ছেন কেন আমাকে? ঠিক আছে, এই তো না রুল 15 গুলো না?
Lord, if your Lordship comes to the rules, let me be pointed in the matter of assistance. I don't want to argue like a counsel appearing for a party. It's only for the purpose of assistance to the court. Kindly come to Rule. Rule 18. Rule 18, I'm sorry. Notwithstanding anything contained in rules 15 to 17 above, the Chief Justice may sign a rule for hearing before any other judge or bench if required by the special circumstances of the case, or if the judge or bench reports or report to the Chief Justice for so doing. Now, my Lord, notwithstanding anything contained in rules 15 to 17 above. Now, what is 15 to 17? So far as Advocate General's petition is concerned, that's dealt with Rule 16. And kindly says the power, Rule 17, rule issued by any court on its own motion shall be dealt with by the particular court, provided that such rules under Section 15 of the Act shall be heard and determined by such bench of judges as the Chief Justice may appoint. Now, notwithstanding anything contained in Rule 17, does take away the power, because it says rules issued by any court on its own motion shall be dealt with by the particular court, provided that such rules, etc. And then, notwithstanding anything contained in Rules 15 to 17 above, the Chief Justice may assign a rule for hearing before any other judge or bench. Mr. Bandopadaya's submission was, you could assign only a rule. And if the rule is not issued by then this court had no jurisdiction to issue the rule. And that is why he submits that rule is not to be heard and your lordships lack jurisdiction. Now, my answer to this is twofold. Before going to the case laws, the Supreme Court has considered these aspects in various decisions. Now, my lord, 19 your lordship says, the court may issue rule nisi or summarily reject the petition or make such order thereupon as thought fit. Now, my lord, may assign a rule for hearing, and then 19 says the court may issue rule or summarily reject or make such order thereupon as thought fit. Only this expression, a petition is placed or an information is laid before the Chief Justice, and the Chief Justice feels this has to be heard. Now, the court means when a court, as its Chief Justice may assign. Because assign a rule for hearing before another judge or bench is required in the special circumstance of the case. Now, if your lordships put a restricted meaning to this, only a rule can be issued. Lord, I was just asking this question to myself, that does it serve the purpose of justice? Can the rule be read in a fashion so as to defeat justice? This is a case of a very serious nature. Some people are standing over the poster of a sitting judge, hurling slogans against the learned judge as also an advocate of this court. And if this is allowed to be continued.
1 second, Mr. Shimpi, 1 second,
Yes,
sorry.
Yes.
Sorry.
No, no, I just put it this way, that if this sort of contempt, in my respectful submission, if not dealt with sternly, then it will only encourage persons not only to disrespect the honorable judges, but also
Sorry, please proceed. Yeah.
Also, the lawyers appearing in the matter. Now, my lord, if your lordship sees the definition of criminal contempt for a second, criminal contempt, it does not mean that we have. Kindly see this definition first. Yes. This is 2C, I believe. Let me see. Because 2B is a civil contempt and 2C. If you kindly give me a second. Criminal contempt means the publication, whether by words, spoken or written, or by signs, or by visible representations or otherwise, of any matter or the doing of any other act whatsoever which scandalizes, here it does not end, or tends to scandalize, or lowers, or tends to lower the authority of any court. So, this is broad enough to take within its ambit any act which has a tendency to scandalize or lower the authority of any court and prejudices or interferes or tends to interfere with the due course of any judicial proceeding. Now, there are two parts. One relating to the honorable judge who was dealing with the matter. His posters have been trampled. They're standing above the and crying slogans, aligning the judge with the counsel so as to do away with the prestige or respect that the High Court commands. And this is by words spoken or written. The poster itself is something written. There they stand on it, put it under their shoes, and shouting slogans which have undermined or lowered the authority of the court, scandalizing the court, or in any event, it tends to scandalize or lowers the authority of the court. It's one. Now, the term court is not only to include only the judges, but it deals with the institution as a whole, which includes even the lawyers. Now, if somebody comes and tells me, if you appear in this matter, we'll break your legs, your son will not come back from the workplace. We'll ensure that. And as a result of that, it's creating pressure, and I do not appear. is it not interfering with the due course of any judicial proceeding? So, staging really a garrow before, in front of the chambers of the learned advocates who are appearing and shouting slogans.
Yes.
Rule has been issued by this bench.
Yes.
After the matter was assigned to this bench, your lordships did not issue a rule on the first day. Lordship directed that affidavits may be filed by those against whom contempt is alleged, since they had chosen not to file any opposition to the allegations. Your lordships were pleased to direct issuance of rule. So that means that a matter has been assigned to a bench by the Honorable the Chief Justice, which is within his power as the master of the roster, and your lordships have been pleased to issue a rule after giving them an opportunity of placing their case. Not mechanically or just, all right, issue a rule. Not like that. Your lordships were careful about not doing any injustice to anyone. Now, look, I guess I was telling your lordships in one matter before a high court. A civil content matter was assigned by the Chief Justice to another judge. The matter was taken up to Supreme Court. And the Supreme Court said, what's wrong in it? But no. Civil contempt has to be heard by the judge who had passed the order. Well, that does not take away the power of the Chief Justice to assign. He is the master of the roster. I shall place that case for your lordship's very kind consideration, because there the observations are absolutely apt on this question. Lord, my learned junior, Mr. Samim Ahmed, is there. In fact, I intended to go to your lordship physically and place those cases. But since I am not keeping well, I said, I shall, if I can, I shall go. Otherwise, I shall address the court or on a virtual mode. Now, Lord, the cases may be permitted to be cited by Mr. Samim Ahmed. First of all, the case of Madhya Pradesh High Court. Now, Lord, there a single judge's matter was assigned before another single judge.
It appears Mr. Ahmed is hearing of the judgment for the first time.
No.
From his expression.
Yesterday, we had a conference of 2 hours.
He refuses to stand up. Just now he has stood up.
Possibly he has not heard what I said. He was so engrossed that the sound has stopped. I did not disturb his concentration. And there are cases where, my lord, these questions have been dealt with. Say, for example, I start with one which Mr. Samim Ahmed has dealt with a number of times. Biman Bosch's case that was cited by Mr. Bandyopadhyay.
This is 2010 ATCC 673.
That we have a copy already, don't we?
Please repeat the citation once.
This is 2010 ATCC 673.
2010 8 SCC 673.
Yes.
এই তোদের কল্যাণদাও দিয়েছিল।
Yes, they have cited.
না আমার থাকবে কোথাও একটা, ওরা সাইড করেছে, কপি বাড়িয়ে লাভ কি?
We are also relying on this judgment only.
Hmm?
We are also relying on this.
Correct. You tell us which paragraphs you are relying on?
Yes.
তাই তো, এটা আমারই হাতে, আমারই হাতে।
আমারটাও থাকবে, দেখো।
Well, the issue
যে ফাইলগুলো যার না সেগুলো তাকে
issue in regards to
জাজমেন্ট গুলো দেখিয়েছিল, যে ফাইলগুলো যে জজ সাহেবের সাইটেশনের সেগুলো দিয়ে দিন। কমন জাজমেন্ট হবেই, একাধিক জাজমেন্ট।
the issue in regard to requirement of consent of Advocate General has been framed in paragraph 17. While dealing with this issue, court has observed when it is required and when it is not. And if I read from paragraph 18 onwards, paragraph 18 basically the code of the previous judgment. If the High Court acts on information derived from its own sources, such as from a perusal of the records of a subordinate court or on reading of a report in a newspaper or hearing a public speech without there being any reference from the subordinate court or the Advocate General, it can be said to have taken cognizance on its own motion. But if the High Court is directly moved by a petition by a private person feeling aggrieved, not being the Advocate General, can the High Court refuse to entertain the same on the ground that it has been made without the consent in writing of the Advocate General? It appears to us that the High Court has, in such a situation, a discretion to refuse to entertain the petition or to take cognizance on its own motion on the basis of information supplied to it in that petition. If the petitioner is a responsible member of the legal profession, it may act suo motu. More so if the petitioner advocate, as in the instant case, prays that the court should act suo motu. The whole object of the prescribing the procedural modes of taking cognizance in section 15 is to safeguard the valuable time of the High Court or Supreme Court for being wasted by frivolous complaint of the contempt of court. If the High Court is prima facie satisfied that the information received by it regarding the commission of contempt of a subordinate court is not frivolous, and the contempt alleged is not merely technical or trivial, it may in its discretion act suo motu and commence the proceedings against the contemptor. However, this mode of taking suo motu cognizance of contempt of a subordinate court should be resorted to sparingly where the contempt concerned is of a grave and serious nature.
Lord, here this case is a very serious one and of a very grave nature, and your lordships, after going to the petition, were pleased to observe that this is a very serious matter. Therefore, we give them an opportunity first to deal with it, and thereafter, if we feel that no proper explanation has been given of their conduct, then we'll issue a rule. And that is what your lordships did. Now, the persons have apologized. And one said, well, I was not here. I was told specifically by my Lord Justice Bhattacharya that Kunal Ghosh aspect. I shall come to that absolutely in a different manner. But so far as all others are concerned, the issue that High Court cannot take suo motu cognizance in absence of complaint with the permission of the Advocate General is not a proper reading of it.
In reference to this judgment, if your lordship kindly takes up
the order by which it was assigned to this bench, my lord, it records both the affidavits are related the acts of obstruction of justice, intimation of the advocates, scandalization of the court, and the interference with the administration of justice committed on so-and-so date at so-and-so place. Hence, praying for taking up the matter as suo motu proceedings for criminal contempt under the Contempt of Court Act 1971. Both the affidavits are filed by so-and-so. The matters are most humbly placed with Honorable Lordship for appropriate order. Then order. The matter was mentioned before the courtroom number so-and-so by several learned advocates who were in uniform, in their submission that the incident which occurred on so-and-so date at so-and-so place is a clear interference to the administration of justice and a threat meted out to the judiciary and the learned members of the bar. Video clippings was shown to us in which it was seen that one of the person was stamping on the photographs of the honorable judge with his feet. The interview given to the concerned YouTube channel was translated and explained to the undersigned in English, from which it appeared prima facie clear that the person was mentioning about the names of honorable judge present and past. There was also mention about the orders passed by the Honorable Supreme Court, and the names of the senior advocates were also taken. Thus, I am convinced that the matter requires immediate attention to protect the image of the judiciary from the scurrilous and the baseless allegations. Hence, I deem it appropriate to constitute the following special bench. Now, this was the observation of the Honorable Chief Justice. Now, in this context, may I read the subsequent paragraphs also, which is also relevant. That court has distinguished contempt in a suo motu proceedings and contempt by a petition filed by the private person. That paragraph 23 and 24. It is settled law that the high courts, even while exercising their power under Article 215 of the Constitution to punish the contempt, the procedure prescribed by law is required to be followed. High Court in the present case relied on a decision of the court so-and-so, wherein this court overruled the objection raised on behalf of the alleged contemptor that the contempt petition filed by the Supreme Court without the consent of the adversary was not maintainable. The decision was rendered prior to the act coming into force. There was no provision of law at the relevant time which prevented the court from entertaining the petition filed by the interested person, even without prior consent in writing of the Attorney General, of the Advocate General, or the Advocate General, as the case may be. The High Court in the present case rested in its conclusion, relying on the amendments made in the petition, stating that even a suo motu contempt proceedings may be initiated at the instance of the petitioners on going through a newspaper. Be it noted that there is no prayer in the contempt petition filed by the respondent to initiate suo motu proceedings. We are unable to sustain the findings of the High Court in this regard, but the same is not supported by any material available on record. The order dated so-and-so and the rule issued is in clear and categorical terms reflects the law was set in motion exclusively based on the amendments made in the petition and the affidavit of verification filed in
kindly pause here for a moment. In our case, your lordship will find that there was no petition. There was merely affidavits for the purpose of bringing it to the notice of the court. Now, mere filing of affidavit does not amount to a petition. And the court, your lordship will see in the decisions to be cited that the court can take a notice of statements made on oath by responsible persons like lawyers and act on it suo motu. Therefore, in our case, this factor is absent. And your lordships may kindly remember that on the very first day, I told your lordship that I am not appearing for any party, but I am for the informer. I am for some of the persons who have informed the court that this has happened. Now, my lord, in the order sheet, I find my learned friend, Mr. Ahmed, has made it available to me. It makes appearing for the parties, appearing for petitioner, appearing for petitioner. We never appeared for the petitioner. We appeared for the informer in this case. One might say complainant, I understand, but not petitioner. To be a petitioner, there has to be a petition. And the texture and language of the affidavit will clearly demonstrate that we were not petitioners. Therefore, in this case, we stand on a firmer footing. In fact, I would have gone to a stage further to say, since these appearances are marked by the court officers, so they have marked it for the petitioners. It's not a direction of the court. Therefore, Lord, all that has been made is a complaint to show before the court that look here, this has happened. One man go to that extent that I am submitting that this is a fit case for taking up the case suo motu. That does not make it an application. And in one versus case, the Supreme Court said, look here, it said it does not even make a prayer for issuing a rule suo motu. So if that is not there, that was based on a petition. If it is based on a petition, then Lord, Section 15 is attracted.
So, Mr. Sengupta,
Yes, sir.
the way you are putting it, can you say this, that the Honorable Chief Justice, the affidavits were filed, those were captioned also as complaints. And their
Yes.
suo motu rule was prayed for before the court's jurisdiction was sought to be invoked, that you issue a suo motu rule. We are not the petitioners.
Yes.
Those materials were before the court, and
Yes.
as is apparent from the Chief Justice's initial order assigning before us, that video clippings were produced, those
Yes.
affidavits were there. On these materials, Honorable Chief was of the opinion that this matter is serious, a bench should be constituted and place the materials before us.
Yes.
And then we also gathered further materials by seeking affidavits from the alleged contemners. And after getting those materials, on the first day, we did not issue a rule, as you said. And then it is this court which issued the rule for the first time
Yes.
after getting those materials, including the video clippings.
Yes,
So this can be governed by, arguably, by Rule 17, which does not confine it to the Chief Justice. It says
Yes.
rules issued by any court on its own motion shall be dealt with by that particular court. So the chief or the chief judge does is only constitutes our bench, assigns these materials to us, and leaves it on us to take a call as to whether we shall issue a rule of contempt. This is
Your
the
Lordship, yes, your Lordship has put it more precisely than I could. I was just drawing your Lordship's attention to the expression, notwithstanding anything. It does not mean
it's
that-
over and above. It's additional. In
that's
addition.
That's right.
That's very
Therefore, it's one thing. Say this, and it's another thing. Rules issued by any court shall be dealt with by particular court, provided such rules under Section 15 shall be heard and determined by such bench, that is as court judge may appoint. Mr. Bandyopadhyay harped on repeatedly rules. Unless you issue a rule, it cannot be assigned. Which means the general power of assignment of the Chief Justice is sought to be curtailed by such interpretation. Because such an interpretation will go against all canons of procedural justice, because the Honorable Chief Justice's power, general power of dealing with matters is sought to be curtailed by such interpretation. Lord, I shall show the decision later on. Supreme Court has clearly said rules of, this is in R.N. Jadi versus Sambut, 2007, 6 SCC 40. 420. Now, don't go by the number of the page.
And
Yes.
particularly since this is criminal
Yes.
contempt. So
Yes. So
it has changed now. Now under the new provisions, it has changed. So,
it has
so no
changed,
difficulty.
yes, but not we always, even now we say he is a 420. They will not, 420 has got its own place in common vocabulary. Now, they are supposed to say the rules of procedure. Now, umpteen number of cases, I shall not trouble your lordship with those cases. I believe there is no dispute.
Sir, Prashant Bhushan's case.
আসছি আগে ওটা শেষ করো দিও অবশ্যটা শেষ করো তারপর
Yes, Mr. Nuthan.
Number rules of procedure are intended to be a handmaid in the administration of justice and not mistress of it. Therefore, rules of procedure cannot be urged to defeat the substantive purpose of law. And if such a meaning is put, and the miscreants, if I may use the expression, are let off on such technical objections, then it will not only set a bad precedent, but will encourage people at large to take such plea.
We have to paraphrase the language because these words cannot be used now in view of the handbook issued by the Supreme Court. Mistress and all, we cannot use those things. So we'll paraphrase.
Lord, certainly, but I said if I may be permitted to
It's
say
the language
so.
of the judgment you are citing, so you cannot help. So we'll paraphrase.
Not the least, say the best. Now, Lord, this conclusion, we are placing Biman Bosch's case. Mr. Ahmed will read on the subsequent paragraphs which are relevant. I wish, Lord, I could be personally there to assist your lordships. But
now, paragraph 24, of Biman Bosch's case, is distinguishes in the particularly in the middle,
Exclusively.
Yes.
Exclusively.
Yes.
It is exclusively on the affidavit. If it's exclusively on the affidavit, then
no.
That is the distinction.
Now,
and 25 dilutes it for.
On the next judgment, shall I refer the next judgment?
Yes.
This is of 2021, 1 SCC, page 745.
Was this also cited by Deb?
No.
2021.
1 SCC, page 745.
This is Prashant Bhushan's case, where Lord the Supreme Court had taken a serious view of observations made by the London advocate.
And I'm reading only paragraph 18,
রুলগুলো ভীষণ বাজে দীপঙ্কর তুমি এখানেও পড়ো না ওখানে ওই কোর্টে পড়ো
only paragraph 18. From the perusal of various judgments of this court, including those of constitutional benches, it could be seen that the sources of powers of this court for proceedings of an action of contempt is under Article 129. it has further been held that power of this court to initiate contempt proceedings is not in any manner limited by the provisions of the Contempt of Court Act 1971.
This is what I was submitting before you.
It has been held that the court is vested with the constitutional powers to deal with the contempt, and Section 15 is not the source of power to issue notice for contempt. It only provides the procedure in which such contempt is to be initiated. It has been held that insofar as suo motu petitions are concerned, the court can very well initiate proceedings suo motu on the basis of information received by it. The only requirement is that the procedure as prescribed in the judgment of PN Duda has to be followed. In the present case, the same has undoubtedly been followed. It is also equally settled that as far as suo motu petitions are concerned, there is no requirement for taking consent of anybody, including the learned Attorney General, because the court is exercising its inherent power to issue notice for contempt. It is equally well settled that once the court takes cognizance, the matter is purely between the court and the contemner. The only requirement is that the procedure followed is required to be just and fair and in accordance with the principle of natural justice. In the present case, the notice issued to the alleged contemner clearly mentions the tweets on the basis of which court is proceeding suo motu. The alleged contemner 1 has also clearly understood the basis on which the court is proceeding against him, as is evident from the elaborate affidavit in reply filed by him.
So for us, it is Article 215.
Article 215.
We'll read 120 for 129, 215.
215.
Yes.
Natural justice is the only.
Two things from this judgment, this paragraph.
And notice this is a 3 judge bench. The
Yes.
other one was a 2 judge bench. Yes.
I'm not, I made my submission that the source of power to punish for contempt comes from Article 215, not Section 15 of the Contempt of Courts Act. Therefore, such constitutional power cannot be taken away or abridged in any manner by any legislation or enactment of any legislature. And this is more so in respect of rules. This is a case in support of the submission that I have made. And my lord, another thing, Lord, as I said, my lord, is supported by this judgment. That means it's a purpose. The purpose of it. Once the court takes out cognizance by suo motu rule, the matter goes out of the hands of everybody except in the court. Matters between the court and the contemner. These procedural objections cannot be allowed to frustrate the requirement of justice. But the next case, or this case, any further paragraph I marked, I don't remember.
Sir, I don't think any
further paragraph. না বললাম যদি কিছু মার্ক করে থাকি
না স্যার
No, he has not marked anything else. This is sufficient.
Fine.
Move on to the next.
We are not citing any more judgment.
We are not citing any other judgment, Mr. Sengupta. Now on respondent number 8, you can just.
Lord, I just point out there are judgments cited by Mr. Bandyopadhyay, whether that should be distinguished or not. If your lordship, these are all judgments, your lordships We'll read it for advancing the.
Yeah, Mr. Sengupta, I don't think those judgments need to be dealt with.
Fine, I'm grateful to your lordship.
Yes.
Therefore, my lord, I give it up. Now, my lord.
Principles of law are fairly well settled.
Yes, yes. Now, my lord, so far as respondent number 8 is concerned, my lord, what was the basic stand? My lord, I was not present there. I was holding a press conference before in Lake Town or town, Newtown. But it's not an essential ingredient of criminal contempt to be present in the place of contempt. I can commit criminal contempt sitting here while submitting before the court. So I was addressing a press conference is no ground to say that criminal contempt has not been committed. And my lord, I drew your lordship's kind attention to section 2, subsection C of the Contempt of Courts Act to say criminal contempt is that which tends to lure, tends to scandalize. This tends to is making it very wide. If I sit in Salt Lake, I can still commit criminal contempt that is being staged before the High Court. And your lordship sees the first order that your lordship was pleased to read when it was raised before the Honorable Chief Justice. The Honorable Chief Justice bench recorded that clippings of press conference were translated for the court, and the court was satisfied that against not only one judge, a number of judges, aspersions were made.
Mr. Sengupta, shall we reassemble next week?
Yes, Lord.
Next Thursday week, not tomorrow.
Yes.
Thursday week.
Thursday week.
Mr. Parthu Sharathi Sengupta, Learned Senior Counsel, makes his submission on behalf of one of the informants, on behalf of the informants. Stop. He does not conclude. Paragraph. List this matter once again on OE. Marked 3:30 p.m.
I hope I shall be able to be present before your lordship physically.
Physically, that will be very nice.
Yes, I shall try to do that.
Thank you. Thank you.
Yeah.